Are you good?
Yep.
Okay, I'd like to call to an order the Clayton City Council meeting for December 18, 2018. Let the record reflect that all council members are present, with the exception of Council Member Diaz, who is expected to arrive a bit late. If everyone would please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. So we'll move on to consent calendar, and I do have one speaker card for item 3E, so I think we'll pull that one. Are there any other requests by the council to pull any consent items?
Yeah, item 3I as well.
3I?
Yes, please.
Okay, so is there a motion then to approve all other consent items other than E and I?
I would so move.
Is there a second?
Yeah, second.
So it's been moved and seconded. All those in favor, please say aye. Aye. And no one opposed, so that passes unanimously. So let's go into consent calendar 3E. So I have a speaker card from Nancy Top.
I was just wanting it entered in the record. I can read it if you want me to.
Please come to the mic, and if you can.
I would have to.
Oh, okay.
Because it said something if I just.
Yeah.
Okay, I just wanted to know, since I'm just learning about these trees, and they're my favorite trees in the world. I didn't mind the ones that were removed along Clayton Road that were near the elementary school, because those were obviously, great danger and all that kind of stuff. But the ones that are on Regency El Portal, they abut a creek. And so I wanted to know, were the occupants near the area notified? And were the residents of Clayton in large notified? And if so, where and when? And then was Save Mount Diablo notified, because they own the property that is immediately behind, between El Portal and I'm not sure what street, but Regency and El Portal, below Seminary Hill. And they might have a comment about it or something. I did speak with Mr. Napper, and he explained the arborist and all that. But anyway, I just wanted to know, were all parties in agreement to remove the trees? And it didn't seem to me that it was sufficient reasoning that because the trees are non-native and messy to some people, I don't consider them messy, I love them, I have one in my own yard, that they should be removed. And I just wanted to know where the documentation was that they were not sound, where they are located at that particular location.
Okay, great, thank you. And is there anybody else in the public who would like to comment on that item? Seeing none, could I ask Mr. Napper to address that a little bit?
Yes, certainly. This item goes back actually to the spring, and we've had complaints over a period of years, but recently months, people complaining about the eucalyptus trees in these specific areas in the open space. Messy, that's a subjective word, but I think the connotation of messy means that they are prone to shedding limbs. They also have, some bark that will shed as well. Primarily the ones that are selected are because people over the years and months have complained about their location. As she indicated, they are non-native, so the city did not plant them. We've been trying to trim some of them over a period of years, but it's just, according to the arborist, it's not worth it. The trimming won't, enhance the safety anymore. They need to be removed. And primarily, and most recently, is people who are living near these trees are concerned about the fire aspect of things. Some of these are fairly large eucalyptus oaks, and certainly with the experience in Northern California in trees, it has caused a concern for a number of people when they see those large trees in the areas. So no, we did not notify, we didn't post the area, we didn't notify Save Mount Diablo regarding this, because they are trees that are on city property. However, if the contract is awarded to the actual lowest bidder, because this is a return, we will notify the neighbors before the contractors go out, because obviously the noise and the chainsaws will cause a wondering what is occurring.
Okay.
Can you clarify what the extent of the safety concern is, excluding the fire risk? Like, is it from falling or?
Well, we've had some eucalyptus that have fallen in the creek, the Cardenay Trail area creek, in recent years. We actually, there was going to be 18 council member on here, but we actually removed one this last year, and it was significant chore to get in there because it did actually fall over in the creek area.
I saw that one.
Yeah. There also the concern is because they do shed their limbs. And in fact, a lot of people maybe don't know, but in the downtown area, the park that is called the Grove Park is named after the eucalyptus trees that were there, and I know the removal of that, I wasn't here at the time, but the removal of those trees was because it was a public safety issue. Now, I did talk with Ms. Top ahead of time. There is a sidewalk that goes by on Petar Court, and we've had actually some of the Petar Court residents who back up to that creek because of the fire concern express that the trees need to be removed. And regularly, there's a resident next to a little small open space on Regency Drive where some of the eucalyptus trees are located. He probably calls us once a year and asks that those trees be trimmed because of the safety concern and the fire concern.
Was there an overall assessment of other similarly situated trees in other city-owned land then? Or how were these ones identified?
These were primarily identified, Councilmember, because of complaints arising from residents, and we had staff go out with certified arborists to say, hey, can we save those trees? Can we trim? Should we be trimming those trees? And they have said the trees that are identified for removal should be removed.
Great. Thank you. Are there any other questions? Go
You
ahead.
need to come on up to the mic or bring the mic down to you, Ann.
I was going to keep quiet, but, you know. Okay, here we go. Public safety, and you won't clear the fire lanes. Come on. I'm just, by the way, my name is Ann Stanaway, and I'm at 1553 Haviland Place. If you're going to talk public safety and you're going to get rid of a bunch of trees, fine. In Australia, they call them widow makers for a good reason, because these trees, they shed their limbs, and he's right. But you know what? Blocking the fire lanes leaves us open to all kinds of problems, and it leaves the city open to lawsuits. Once the actual once the first responders can't get in there to do their work at any fire site. So I don't understand why one public safety concern trumps, so to speak, my concern over the safety in the fire lanes. So anyway, there.
Can I ask what fire lanes you're speaking of?
Oh yeah, the Westwood Property Owners Association, Subdivision 6001. All of their streets are designated fire lanes because they're too skinny, and so therefore they're all fire lanes. And they have the signs up there: no parking anytime. They have a red zone, and the people on Haviland Court park in the fire lanes, and they encroach on the fire lanes all the time. And I have been at this. There are several of the sheriffs have gone ahead and proposed fixes, and one actually had the curb painted red, so that this would, you don't park at a red curb. They're parking at the red curb. So it's, what can I say? I can't. I don't understand. So anyway.
Well, thank you. I don't understand either. So who would we direct that question to with regard to, would we talk to the fire department, the police department, the staff?
Well, it's a code enforcement from the police department.
From the police
if I
department.
understand correctly. Do I have that right?
That's correct, and they have been talked to about it, and the status quo is sufficient for the police chief as well as the fire chief.
So let's get back to the eucalyptus tree.
Sure.
We can go back to the other item when it's public public comment. So on the eucalyptus trees and the contract, any other comments? Go ahead.
I was just going to make one comment. Historically, back in the late 80s, before the city purchased what is now the Grove Park, we did have the trees there cleared after one of the trees which overhung the parking lot at the village market shed a very large limb, what most of us would consider a tree-sized limb, onto someone's brand new Cadillac that they had just picked up that day.
and she had just gone in the door of the Village Market when it fell and crushed the car. That was enough incentive for us to realize that those trees, when we looked at the inside of that huge branch, were severely damaged interior. They looked fine from the outside, and every one of them turned out to be rotten. They looked fine from the outside, were severely rotten inside when they were eventually cut down. And so it's very hard to tell unless you kind of x-ray the machine or the trees or do borings or things like that, which also are not good for them. So I think this is absolutely the prudent way to go. And they are trees that, while they are pretty and they smell great, they do become a hazard when they become this large in this climate. They are not really trees that are suitable for public areas. So
I would tend to agree with that. I used to live on in Lydia Lane, and those, in fact, the two trees that were cut down last year or whatever, one behind that actually fell, a 60, 70-foot tree, and took out a good portion of my fence. And I'm glad I wasn't back there when that happened. My concern with this whole thing would be, yes, they are pretty, and I know they're on city property, but people walk along the trails, and while those are dangerous trees, there's nothing going to be replacing them. Is that correct?
That's correct.
Because they're on public property, they grew there wild, if you will.
Right. The city did not plant them, and the
Right.
city, the taxpayers are incurring expense to take care of them, and they're really not trees, if we were to plant along the way, that we would replant. They're also in open space areas and backing up to, as we indicated, properties that are concerned just in general about vegetation. Once you plant a tree, you have to continue to trim a tree, whether you're a private property owner or whether you're a public property owner.
A quick clarification, especially on the trees that are on near Regency, I mean, along the creek, there are other trees there too. These aren't the only trees, I don't think. Or,
Yes, that's true.
Yeah.
So what's our plan to assess the ongoing issue of the existence of similarly situated trees? Do we do like an assessment on some kind of interval?
Well, the maintenance department, first off, there's citizens' eyes and ears that take place, and that's what primarily this is to a large degree. And then secondly, maintenance department, they take a look at trees as they do the trails and other things, just, in terms of general condition and so forth. But no, is there an overall plan for extermination of certain trees during, a 5-year period or a 7-year period? No, we'd rather not incur the expense of $176,000 if we didn't think that the trees were necessary to be removed for life safety, as and for a combination of reasons. So, but no, in response to your question, there's no articulated plan that we do an inspection of all trees every 2 or 3 years.
I would move the item.
Is there a second?
Sure, second.
Okay. So all those in favor of approving item 3E, please say aye.
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 Any opposed? No, so I think that passes unanimously. So then we'll go into consent item 3I. And Councilmember Wan, you pulled this, so if you'd like to.
I just had some background questions around this item. It looks like we're purchasing or replacing a vehicle in the fleet that wasn't budgeted or wasn't planned. So my question is really about the overall status of the fleet. It seems reasonable that once in a while we have to replace vehicles. What was the catalyst for selecting this particular vehicle that needed to be replaced? Off cycle, that is.
Yeah, sure. Fair enough questions. This is for our city maintenance department. Our city maintenance department has a total of 9 vehicles right now. Of those 9 vehicles, 7 of them are 2006 year or older. So we have actually a 2011 and a 2015. The rest of them are older than 2006. We do have, as noted in the staff report, a capital equipment replacement fund, we call it a SURF fund, where we amortize the vehicles over a period of expected life or usefulness. All 7 of those vehicles, including the 2000 that we're suggesting be replaced, have been fully amortized. Now, why is this coming up out of cycle? The reason is when the budget was put together in probably mid-spring, we had a maintenance supervisor who was retiring and was not looking in terms of what was going to occur in the following year. We now have a new maintenance supervisor who's very energetic. He's starting to take a hold of ownership of the fleet and the vehicles, maintaining them at greater standards. The dual cab F350, as you've seen pictures, actually has the broader wheel wells over the rear. And interestingly enough, because it's not driven enough and it's wider than the other F250s, when some of our maintenance workers drive it and they think they have gone through spaces, in some areas that the 250 went, the 350 didn't make it. And so it's being, battered and beat up. It has 106,000 miles on it. And so when the new maintenance supervisor came on board, one of the things I asked him, I required that he take a look at the fleet inventory that we have, making sure we're not overfleeted, if you will, and how is he assigning the equipment and accordingly. He has, since that time period, he's actually sectored off the city into 2 sections, and he's created 2 crews that will take care solely each of those areas. So that's greater accountability and greater ownership of the areas for the maintenance. How's that dovetail into this? Part of the reason is that he needs to spin out this older one and get a dual cab 250, so he can transport personnel and they can stay out in the field as opposed to shuttling people back and forth. For instance, just this week, and a lot of times we don't know when the courts will assign us, but we have what's called work alternative program individuals that'll come out. We will then shuttle them out to a site and then bring them back in accordingly. So that it really was just transitioning that Mr. Warburton is now responsible for the maintenance department, and this is the way he wishes to deploy this. Rather than buying a new vehicle, which, as most of you know, you drive that off a lot, it gets immediate, 20% depreciation just about when you drive it off. And also given the fact that sometimes they're not as careful with some of the equipment, I thought that buying a used vehicle that had only 26,000 miles on it was a good way to go. Ironically, the 2015 that's being proposed for purchase would be one of the newest vehicles, if not the newest vehicle in the fleet.
So what's the typical cycle where they rotate out? Is it just as needed, or is there a planned decommission time?
We don't, obviously we amortize them, and then we do an assessment of the vehicle after the amortization period to determine, do we really need to shed ourselves of that vehicle, or does this still have useful life? Because often, Councilmember Juan, having a diesel engine, that's not hard on the diesel engine for the types of miles that we put on them, and they idle great and in that respect. So as you can tell, by 7 out of the 9 are 2006 year or older, we utilize the vehicles as long as possible, but when it reaches a point where it's starting to break and we're putting more money into it than it's actually valued, the trade-in value for the year 2000 vehicle is like $6,000, and this dealer actually was offering more than others. They only wanted to give us like $3,000 for it. So we do an evaluation per vehicle. It isn't just automatic, it reached a certain age and now it's no longer good.
Okay.
Are there any other comments from anybody? I do want to add just a note. I mean, I do appreciate staff actually looking at, instead of just buying a new replacement vehicle, actually looking at potential used vehicles, because I think that is a significant savings of, I think, $20,000 to $25,000 in this case. So
Thank you.
So is there a motion to approve?
So we're not going to have any more dualies in the fleet then? No more dual?
You like those?
No, I don't.
Well, we didn't, I wasn't here in 2000 when they bought it, but I don't think it's, Mr. Warburton, is you going to get any more dualies?
There is one other dually in the fleet that Madam Mayor, council members, my name is James Warburton. I am the maintenance supervisor that Mr. Napper was speaking about. I do not intend to have any more dualies in the fleet. In fact, we've kind of downsized from F350s to F250s because of the expense of an F350. The F250 can do all the all the work that we need to do. It has the pulling power, especially with the new technology and turbos and stuff. So, no, to answer your question, I don't plan on buying any more dualies, but there is one other one in the fleet that is a utility body, and it's 8 feet wide instead of 12 feet wide or 10 feet wide or whatever the actual dually that we're trading in is. So,
Sounds good.
Great,
Thank you.
Thank you. So is there a motion, unless there's anything else, is there a motion?
I move.
Second.
So it's been moved and seconded. All those in favor of item 3I, please say aye.
Aye.
And no one opposed, so it passes unanimously. So then let's move on. Our next item is item 4, recognitions and presentations. We do not have any. So let's go to item number 5, which is reports. And we do have first the report from Mr. Chipero for the Planning Commission.
Hi there, AJ Chipero from the Planning Commission. We met on Tuesday, December 11th, without CW. And so the four of us unanimously voted to approve UP-02-1A, which was the permit to allow the preschool at St. John's Episcopali Church on 5555 Clayton Road. This preschool will operate Monday through Friday from 6:30 a.m. to 6 p.m., and it will accommodate up to 60 children when it gets fully up to speed. They didn't have to build anything. The buildings are existent, so we approved that. And we also voted to approve the Creekside Terrace Development Plan for another year. This is the property that's on Oak Street that has the 2 vacant buildings that are quite an eyesore. If you're not familiar with this particular plan, I encourage you to go to the agenda for the Planning Commission for the 11th of December. It's a nice looking plan, so. Any questions?
Any questions?
I have some questions.
Sure.
Why do we continue to approve the Creekside Terrace development when I'm not sure how long it's been? It's been 7-ish years?
Longer than
Can
that,
I direct
believe.
that
Give or
maybe
take.
to Ms. Gentry or Mr. Napper?
So the Clayton Municipal Code only allows 1-year extensions to occur of entitlements or approvals, and the city is the underlying property owner and project sponsor for this particular project, and there is value in those entitlements for potential future negotiations with the development community that may be interested in one day purchasing the land, as well as those approvals to build what was originally approved by the council back in July of 2010.
How much is the development allowed to deviate from the entitlement that was granted before they lose value?
It depends on whether or not the deviations are determined to be significant or not. And there's also an underlying California Environmental Quality Act environmental review on that property. So that is also a driver of what was contemplated as part of those approvals. So it really depends on the deviation.
Who's responsible for making the assessment if it's substantial, or sorry, you said significant, if it's significant or not?
That typically is done by myself as the community development director.
Are there like established guidelines for that, or is it more of a judgment call?
It depends, really on what level of changes are going to be proposed, but typically as staff, we tend to err on the side of conservatism and would more than likely, if there's something that's considered to be significant, we will definitely send it to the appropriate hearing body for consideration.
Okay, because I guess I'm not sure what the city gains in continuing the approvals in perpetuity. Is there a limit on how often we can do it, or can we continue it forever, every year?
I would be under the purview of the Planning Commission to determine whether or not to.
I mean, if we were so inclined, we could continue each year.
Well, the Planning Commission can decide to continue that. However, the real property decision makers is the city council. So the city council could choose not to pursue those entitlements, and I would, stress that would be more as a real property decision rather than a land use decision.
If I could, council member, if the permit's been extended by the Planning Commission action to January 6, 2020, is that correct?
That's correct.
So if I mean, staff has been moving forward with past consensus that was the direction. If there is a question of we should do an about face or end that, then that's something that the city council, who is the property owner of those 3 properties, would need to direct staff accordingly.
Yeah. Because we're on track to demolish those buildings shortly, right?
That's correct.
Do we have, we had talked earlier, I think, about whether if there were to be a developer to purchase and develop this land, then they would typically incur the cost of demolishing, but we're doing it because of various safety and, what do you call it, attractive nuisance concerns. Is that about right?
That's correct. We had hoped that during the time period when the land use entitlements were ultimately obtained by the city and to today, the theory that you indicated that a developer would come in and that the developer then would, by the granting of the property and the entitlements, would do the demolition of the buildings and everything would be great. We would save the taxpayers money. However, what has happened is that since nothing has occurred that's fulfilled that in principle, we are seeing that the buildings, they're really bungalows that were put on pads at the time, and from my understanding were not intended to stay there forever. They have degraded over a period of time to the point they're uninhabitable. There's more expense than what we've incurred to date, $7,700 to tie up and cap up the utilities. And then I can tell you that I get complaints periodically, primarily from parents of kids who they drop off at that section for elementary school, because if the parent doesn't get there on time, they'll find their kids playing in the back or on the bungalows, and they indicate to me that it's an attractive nuisance. So actually, by law, that means we are on actual notice, not constructive notice. We're on actual notice. And then secondarily, it's we don't want the kids, for whatever reasons, hanging out behind a building that we can't see from the street for police purposes.
And obviously, just because a site is developed doesn't mean the developer or anybody would have to develop it that way. It just preserves the option. So I think what the Planning Commission did is merely, a site that has been previously entitled for a specific project, they're just preserving that entitlement. But if another proposal came forth, the old proposal can go away just as easily, so it doesn't tie anybody in that regard.
I mean, I guess my thinking on that is if we're maintaining these development entitlements, if doing so crowds out the interest of other things. Yes, someone can come in, but if it's stated that the city wants this to be done because we own the land and we've maintained these entitlements, it gives the impression that this is what we want built there. And I'm wondering if that doesn't crowd out other interested parties for alternative uses. I'm not sure what we gain from it. It doesn't seem like we gain a lot from maintaining it for this long. It's been 7 or 8 years. It doesn't look like it's happening.
Right. Obviously, there's always value in having a site that is entitled, and if you can entitle a site, it removes a certain amount of uncertainty from a potential developer. So there's absolutely value, and I don't think we've agendized this item for tonight. But
that's exactly right.
So there is potential value, and like I said, I don't think the city.
It's not value to us, right? It's value to the.
It's value to the
the
city,
buyer.
absolutely, because it's the value of the land that the city owns, and if it's entitled, it's presumably worth more than if it wasn't entitled.
Correct.
So if you don't extend them, you're potentially giving away value by having a vacant lot with no entitlements. But it doesn't tie the city in any regard. We haven't made a decision about any development proposal other than the entitlement that exists there today. But should we procedurally?
Yes, I think we've gotten a little farther off topic than the agenda item. So if there is a desire to talk about whether to continue the entitlements past the 2020 date, I'd suggest we agendize that for a future meeting.
Okay. So thank you, Mr. Chikara.
Happy New Year.
Good report.
Thank you.
So, and then Trails and Landscaping Committee, I don't know if we have anybody from there. I don't think we do. So any reports from city manager or staff?
Yes, thank you, Mayor Catalano. Just wanted to remind the public, I know the council's aware, but we are now advertising for the vacancy on the City Planning Commission. That's available. The application is available on our website. We've posted it also on our boards as well. If anyone is interested, the only requirement is, well, there's a couple of requirements. You have to be a registered voter of the city, and that's about the extent of it. We are hoping to have the applications filed by the week before your next meeting, because we anticipate then, depending upon the number of applicants, we would schedule a meeting of the whole of the City Council who would interview Planning Commission applicants, and then later that evening your selection would be determined. So again, if people are interested serving on the Planning Commission, please do look for that and pick up your application and make that filing. The other is just an announcement once again that City Hall will be closed next week through and until January 2nd for the holidays. The police station will primarily be open except on Christmas Eve, Christmas Day, New Year's Eve, and New Year's Day. Police services continue 24/7. They don't get holidays. And our maintenance department will also still be on duty. But third floor, if there's business to conduct, recommend you get in for the remainder of this week. Otherwise, we'll see you in the new year. Thank you, Mayor.
Great, thank you. So let's move on to City Council reports. Mr. Diaz, would you like to start?
I have a couple of things. One, attended the mayor's conference, and for a second time I availed myself of the opportunity to meet with the individuals that are actually running the program for the what's called the realignment or the AB9 process, and I'm going to be following up with them further at their office to get more clarity on just precisely what they offer and what they can do to at least help communicate with our community on the status of that and how that proceeds. Secondly, at the request of our state senator's office, I met with their staff to kind of discuss things on a post-election basis and some of the future things we maybe see coming from the state of California, the legislature, and so there's more to come on that. Also met with our Assembly member Tim Grayson personally on another matter related to some other organization that I belong to and can help facilitate with insight into the legislative process. That concludes my report. Thank you.
Great, thank you. Councilmember Wolf?
Nothing from me.
Okay. Councilmember Juan?
Becoming the vice chair of the GAD. I spent a lot of time reading through all the formation documents of the GAD, which I am now calling.
It's a caffeine.
It was interesting. That was it.
Great, thank you. Councilmember Pierce?
Well, thank you for doing that. That's a deep trudge. Yes, I had the honor of attending the Balfour Road interchange ribbon cutting on Highway 4 last week. That was the culmination of about a 15-year project, and one that we as a county expedited in East County to give the folks out there access to the rest of the county, and actually took action to defer projects from the rest of the county to that project to get it done in as quick a manner as we possibly could. That is the last major interchange that is planned for now. There are other projects eventually to come, but they will wait their turn. But it was an exciting day to be out there and helping East County celebrate. I also attended the Bay Area Council Economic Institute meeting in San Francisco. We were talking about the organization of the Institute and plans for the future and future studies. There are several studies coming out very soon, which I will forward to you as they appear, talking about the regional housing and other items that are sort of top of mind legislatively this next year. I had 6 meetings of the Metropolitan Transportation Commission on behalf of ABAG. I also attended the Transpec meeting, which I currently chair, and we elected our new chair to take effect in February. And we also reappointed Luella Haskew as one of the Contra Costa Transportation Authority delegates from Transpac. And I helped with an Association of Bay Area Governments workshop on the CASA project, which is the committee to house the Bay Area. And that was a very interesting discussion, and I will give you a little bit more of an update at another time.
Okay, great, thank you. So I attended also the Mayor's Conference in Walnut Creek on Thursday, December 6th. That one, since it was in December, did not have any formal presentation. It was really more about the reorganizations that had taken place in other cities. Some of them had already reorganized and some of them were about to reorganize. I did attend just as a participant, but I think we had a very lovely, Clayton Historical Society had a very lovely Christmas home tour on December 9th, so I was just a participant there. And then on Monday, December 10th, I attended the Trails and Landscaping Committee meeting right here. So I think that concludes our reports. Let's move on to item number 6, which is public comment on non-agenda items. So this is the portion of the meeting when any member of the public can address the council on any item that's not on the agenda. I do have one speaker card, but anyone else can speak as well. Brian Budell.
Thank you, Madam Mayor and Council Member. I'm speaking on a subject that I don't know has ever come up before, which is the city's use of glyphosate-based herbicides. As many of you may be aware, the glyphosate, which is commonly known as Roundup or Ranger, has been recognized now by the state of California as a known carcinogen. You may also be aware that there was a lawsuit recently filed against the manufacturer of, I'm just going to call it Roundup, over in San Francisco, which resulted in a net award, an award of $289 million, which included punitive damages, which was reduced to a little meager amount of $78 million by Judge Suzanne Bolanos over there. My concern is, and I confirmed with Mr. Napper before the meeting that Clayton is indeed using a glyphosate-based herbicide as a weed killer. The good news is it seems to be limited to the areas, the median areas, not so much in contact with pets and people, which is a good step, but I don't know that it goes far enough, because I think the city is still potentially exposed to liability, if nothing else, by its own workers, who at some point may file a workers' comp claim, or with a creative plaintiff's attorney, a more serious claim based on exposure to this. It's been linked to the development of non-Hodgkin's lymphoma, and I think it would be pretty hard for the city to escape liability by saying we didn't know, because it's pretty well out there now. Now the rub is, of course, it is a very efficient weed killer, and there's not probably anything that is as good, but there are some alternatives. And speaking as a lawyer who defends against toxic torts, whether you win or lose these lawsuits, it doesn't take long to rack up enough bills, and if you get hit with even a little smidgen of a $288 million verdict, it's a bad rap. So my recommendation and request would be that the city consider a resolution or ordinance which bans the use of glyphosate-based weed killers within Clayton, and look for a suitable alternative, if nothing else, to shield itself from liability. That's it.
Great, thank you. Is anyone else in the public? Yeah, please come up, state your name.
Ann Stanaway, 1553 Haviland Place. Thanks, Brian, for mentioning that. Actually, the Westwood Property Owners Association's landscape developer there, or the landscape maintenance people, actually use Roundup. So it's in Westwood Park, and pets, people, babies, all sit around in Westwood Park, and they all utilize the areas that Roundup is sprayed on routinely. So there you are.
Great, thank you. Is there anyone else who would like to address the council? Seeing none, we'll close public comment. Let's move on to our public hearings, item 7A.
Do we have any response to that? Or
Public
are we
com-
allowed to respond to that?
Public comment is usually the portion of the meeting, because it's not non-agenda items, so it's not something that is up for discussion or decision or something we can do. But certainly, if there's an item that you'd like more further explanation, we can ask staff to explain more, or then we can bring it up for another. We can agendize and bring it back for discussion as well.
Okay.
So just to clarify, as the mayor indicated, the Brown Act doesn't allow you to have a full discussion on items that aren't on the agenda. So you can request an item come back and be placed on the agenda, or ask brief questions or provide brief comments.
Brief?
Brief. Just as in the other item where I stopped the discussion if it went too far, there's not a time limit, but you wouldn't have a full discussion on it since it's not agendized for discussion.
Okay.
Okay, so let's move on to our public hearings, item 7A. So this is the public hearing to consider the introduction and first reading of the proposed city-initiated ordinance number 484, amending Clayton Municipal Code section 17.92 regarding inclusionary housing requirements for the purpose of incorporating rental housing projects into the local housing requirement. If we could have staff report from Ms. Gentry, please.
Thank you. Good evening, Mayor Catalano and council members. This item on the agenda is the consideration of the introduction of an ordinance to include rental housing into the city's inclusionary housing requirements for new development projects as allowed for by AB 1505. In August of 2016, the City Council adopted an inclusionary housing ordinance for home ownership or for sale housing only. The ordinance specifically precluded rental units due to state law and the outcomes of two specific court cases. Those court cases were Palmer 6th Street Properties versus the City of Los Angeles and the California BIA versus the City of San Jose. The Palmer case determined that cities may no longer require developers to construct affordable housing units. The court had concluded that the inclusionary housing ordinances conflicted with and were preempted by the vacancy decontrol provisions of the Costa-Hawkins Rental Housing Act, which allowed residential landlords to set the initial rents. In the California BIA versus the City of San Jose case, it resulted in a determination that inclusionary housing ordinances do not constitute an unjust taking of property, and the result of the court's decision allowed jurisdictions to adopt inclusionary housing ordinances, but only for homeownership or for sale development projects due to the implications of the Palmer decision. So in September of 2017, Governor Brown signed into law AB 1505, which is also known as the Palmer Fix. This law restored the authority to cities and counties to require the inclusion of affordable housing into new rental housing projects, thereby superseding the court's decision in the Palmer case. AB 1505 also requires alternative means of compliance, such as in lieu fees, land dedication, off-site construction, or the acquisition and rehab of existing units. And on April 17th of this year, the City Council directed staff to prepare an ordinance to fold rental housing projects into the city's inclusionary housing requirements as allowed for by AB 1505, and essentially apply the same standards that were applied to homeownership projects, and also apply it to housing types that are defined and counted by the State Department of Housing and Community Development, also known as HCD. So let me discuss the regulatory background just briefly in order to give some context to the proposed ordinance. So state law requires local governments to identify and plan for the existing and projected housing needs of all economic segments of the community in its housing element. State law also requires HCD to forecast statewide housing needs and to allocate the anticipated needs of the regions throughout the state. And for the Bay Area, HCD provides the regional need to the Association of Bay Area Governments, or ABAG, which then allocates the Regional Housing Needs Assessment, or the RHNA, to cities and counties within the ABAG region. So Clayton's current RHNA status, as you can see on the table, Clayton was allocated a total of 141 housing units for this housing element cycle, which is 8 years. And that breakdown is 51 very low income units, 25 low income units, 31 moderate, and 34 above moderate income units. And the next column over shows the number of permits issued since the start of this housing element cycle. And the city has issued 2 building permits for low income units, which were for 2 accessory dwelling units. And then there were 8 permits issued for above moderate income units, which were the 2 housing developments, Verna Way and the St. John's subdivision, for a total of 10 units. And then the table below represents the, and correlates back to the RENA breakdown here, showing what those income eligibility categories look like. So for Contra Costa County, the area median income is $104,400, and each of these income categories is a percentage of that area median income, or AMI. So for instance, a low-income household family of 4, it's going to range from approximately $58,000 upwards of a little over $89,000. Staff would like to note that the income ratio of the required inclusionary housing units have yet to be determined by the City Council, and this has been identified in the ordinance, and staff will subsequently initiate a policy discussion with the Council to establish the appropriate amount for both an affordable housing in lieu fee, as well as to determine the appropriate affordability ratio of very low, low, and moderate income units to achieve compliance with the city's inclusionary housing requirements. So given Clayton's RENA status and the state's clear and repetitive declarations of housing being an issue of statewide concern, and coupled with the legislators' push for local governments to identify actions that will make sites available for affordable housing, as well as assist the development in such housing, the city's state certified housing element identified an implementation measure to require residential projects of 10 or more units to provide a minimum of 10% of the units to be affordable housing units. The adoption of the inclusionary housing ordinance implements the goals and policies of the housing element by codifying the requirements and providing details regarding the process and the standards for both the city and developers to follow. Adoption of the inclusionary housing ordinance to incorporate residential rental units as allowed for by AB 1505 will further the city's goal of accommodating its fair share housing allocation and will help fulfill housing element policies. So the majority of the amendments to the proposed ordinance are mainly to incorporate rental housing units in addition to the previously established for sale housing units, as well as to specify that the ordinance applies to dwelling units defined and counted by HCD. Other proposed changes include providing more discretion to the City Council regarding the approval process as it pertains to the use of alternatives in lieu of constructing the affordable housing units on site. Also, the very low income category was also added and folded into the ordinance for rental housing units. This was specifically precluded in the last inclusionary housing ordinance due to concerns regarding income requirements in order to maintain a home for home ownership purposes. So what impacts will this ordinance have in the current projects that are in the development pipeline? Currently, there is only one project in the city's pipeline that could be impacted. This is the Clayton Senior Housing Project, which has been deemed complete by staff. However, the project does not have vested rights, therefore this proposed ordinance would be applicable to the project. However, the 81-unit project is currently requesting a 35% density bonus under the state density bonus law, which would produce 7 units dedicated to very low income households. However, for this project, case law would apply, which clarified that jurisdictions are required to account the units granted under the density bonus law to be counted towards the inclusionary housing unit requirements, meaning that the project will be meeting the inclusionary housing requirements by default, essentially. The project is proposing 7 very low income units, and the requirements under the existing inclusionary housing ordinance would be 5.9, the way that it's currently proposed this evening. Therefore, would not result in any additional impacts beyond what is already contemplated under density bonus law.
Mindy, if I might, at the top you mentioned that the project has been deemed complete. Those are words that staff understands, but could you explain what that verbiage means, deemed complete?
deemed complete is part of the Permit Streamlining Act, which essentially states that an application has been submitted to the city and there is adequate information to start to process that application.
But it's not been approved.
No, it has not been approved and has not been before any hearing body of the city at all. So what are the options this evening? Obviously, staff has made a recommendation contained in the staff report. However, the city council could choose not to take action on the proposed ordinance, thereby resulting in a partial implementation of its housing element. Staff believes that the city has fulfilled its state requirements with the current ordinance because AB 1505 allows but does not require jurisdictions to include rental housing within its inclusionary housing ordinances. However, by not including rental housing, it could become the favored housing type over for sale because it would not have the requirement in order to set aside units or to pay an in lieu fee. In addition, that does not preclude any action or future action that could be taken by the state, such as during the next state-mandated housing element cycle. Therefore, staff recommends that the City Council motion to have the clerk read ordinance number 484 by title and number only and waive further reading. And secondly, motion to introduce ordinance number 484 to amend the Clayton Municipal Code for the purpose of including rental housing projects into the inclusionary housing requirements as allowed for by AB 1505. And that concludes the staff report, and staff is available for any questions.
Great, thank you very much. So let me maybe mention just two things since we are now for the first time doing it, as the five of us, a public hearing. So procedurally what we'll do is the very first segment is after staff presentation, any one of us can ask clarifying questions or questions of the matter, but without expressing any opinion, since none of us really should form our opinion until we've closed the public hearing. So once we've asked any clarifying questions of staff, then we'll open up for the public comment when any members of the public can provide their comments. Once we conclude the public comment, then we'll bring it back up to the council for any discussion, opinions, and so forth. So are there any questions of staff?
I have questions.
Go ahead.
If we establish an in lieu fee, does the in lieu fee payments satisfy the RENA requirement? I'm assuming no, but.
The payment of an in lieu fee would satisfy the inclusionary requirements, but the actual construction of the units would be satisfying the RENA.
Sorry, can you repeat that one more time?
So the payment of the in lieu fee would be satisfying the inclusionary housing requirements, but it doesn't require the city to construct those units. So the actual construction of the units would therefore be satisfying the RENA. So there actually has to be the production of a unit to qualify as meeting the RENA requirements.
Let me see if I can clarify. So if there's 141 units, as you mentioned, and let's say there's a payment for one unit via an in lieu fee, does that satisfy one of the 141 units?
No, it does not.
Okay. Okay. So on that chart, there were percent gradients for each of the categories of income levels. On the bottom, it says extremely low, and there's 5 gradients, and at the top, there's 4. And the language doesn't match up. Is that supposed to be the same?
So very low, as it's identified in RENA, is actually broken down into 2 different categories, and 50% of very low income is also assumed to be
extremely low?
Extremely low, yes.
And then moderate is also equal to median, is that right? Here?
Yeah, moderate is just below median here. So above moderate is not on the chart, so anything above this would be considered to be above moderate.
Is that like also market?
It's based on income brackets.
Yeah. So anything above is like whatever would be the market rate?
It's, yeah.
Okay. So this ordinance was initiated at the council's direction back in January of this year, right? Like asking
April.
about it.
April.
Okay. I mean, it was listed as a goal, I think, in January.
You're correct. It was identified in the council's goals setting session because we knew the legislation had passed.
Okay. So at that time, what was the rationale for wanting to add rental units in the inclusionary housing requirement? I mean, is there a stated goal that we said that this is why we're doing it?
There's a goal identified within the city's housing element that establishes essentially creating an inclusionary housing ordinance, and that's what this ordinance is reflecting, is kind of the nuts and bolts in the application of that housing element goal and policy. And because of state law and because of those 2 court cases that I discussed earlier, it prevented the city from actually including rental housing within the originally contemplated ordinance back in August of 2016.
Okay.
So there was also a policy discussion in front of the council that staff asked if, this should be considered and amended, and council provided direction to staff that yes, it should be. So staff is now back returning with the amended ordinance.
Okay. Would the density bonus cover the inclusionary requirement for the project that you mentioned if the inclusionary requirement were at a different rate? You had mentioned that at its current rate of proposed 10%, and the requirement is 5.9 units, and the proposal contained 7 units. And it seems like per the 1505, it states that if you are at 15% inclusionary or less, that is within safe harbor is the wrong word, but within safe harbor of not being questioned on it. So what would the number of units be if we were to raise the inclusionary requirement to 15% rather than 10?
So it would probably be about 9 units. So it would be exceeding state density bonus law.
Okay. Are we allowed to have a different inclusionary requirement for the rental component versus the purchase component?
Yeah, yes.
Okay. Okay, let's see. So if the city doesn't include rental units in the inclusionary rule, can we favor development of units for purchase because that would go towards our RENA requirement rather than a rental unit that would not?
Sure, can you ask the question again?
If you have 2 like developments being proposed, one for rent and one for sale, and this ordinance were not to be adopted, then is the city allowed to favor approval of a development that is for sale only because that would satisfy our RENA requirement, whereas the rental would not for these inclusionary levels?
I think you'd get in trouble with the Housing Accountability Act pretty quickly if you started favoring one type of development over another.
Even though it would be to satisfy a requirement?
If you were the developer and got denied because of whether you're doing rental or ownership, I think as a developer, you'd pretty quickly pull up the Housing Accountability Act and find a way in which the city could not deny you for that reason.
Under what basis?
Based on the Housing Accountability Act.
Like, is there something specific that says you could not favor one over the other?
The Housing Accountability Act includes some ways in which the city can deny housing projects like health and safety and a few other things like that. But if you're merely doing it for, I think you'd have to dig deep for a city to find a reason that would not run you foul with the Housing Accountability Act, just for that reason.
Okay. Because, I mean, I guess I'd like to explore further whether or not what the contours of that is, because it seems like if we have a RENA requirement and one type of development satisfies it and another doesn't, it seems like the city would want to encourage that type of development rather than the other so as to satisfy our requirement. That seems reasonable to me.
And I think that's why this item is in front of us today, because now with the PAMA fix, effective as of January 1, 2018, the cities can impose inclusionary requirements on rental units, and prior to 11 and a half months ago, we were not allowed to do that.
So then, would you say prior to 11 and a half months ago, we could favor?
Prior to 11 and a half months ago, legally, we weren't allowed to require inclusionary units that were rental. And so with this new fix, most of the cities who had inclusionary housing ordinances are updating it as what's before you to include rental housing.
So it applies to everything.
Right.
Yeah, I mean, I understand what the ordinance does. I guess my question is more along the lines of, does this take away an option that we may have if we were to not pass it? And I guess that's a question of law, whether or not that's allowable.
I think if your question is if you don't want to have it apply to rental housing, then you would not adopt the ordinance. And
if we so did, then would we be able to favor?
I don't think you're favoring it. So if a rental project came before you, if it complied with all of our zoning and general plan and other requirements, you wouldn't be able to say, well, we prefer a single family home as opposed to the multifamily home, if that's your question.
Well, that's a question of density. The delineation is rent versus buy, right?
Owner occupied.
Oh, owner occupied. Okay.
Right. No, I don't think we would be able to do that. So I think the only issue before you is whether you prefer to also require inclusionary housing for rental units or not.
Okay. I guess my last question is, at the 2014 meeting, we determined that this ordinance, the original inclusionary ordinance, would not result in adverse environmental impact. Again, essentially, CEQA wasn't applicable. Does this change that, or this impact that assessment at all, or what was the basis for that determination?
So there was actually an initial study, negative declaration, that was done to evaluate the environmental impacts of the city's housing element, and there were no identifiable impacts, and this particular goal or ordinance was actually addressed during the adoption of that original environmental document back in 2014.
Okay.
Does anyone else have any questions if you were done? Mr. Wan, are you?
I think I'm good, thanks.
Okay. Any other questions? Go ahead.
I actually had a couple. And this is getting into the weeds, I realize, but in section 17.92.02 under applicability, item C there, this is talking about the chapter would apply to all residential developments except for those with less than 10 units, those prior to, who had obtained their building permits prior to the date of the ordinance. And another one which wouldn't have occurred to me, honestly, ahead of time, but any dwelling unit or residential development which is damaged or destroyed by fire or natural catastrophe, so long as the use of the reconstructed building and the number of dwelling units remain the same. So that could be one unit, correct? Okay.
Correct.
And the cost of such rehabilitation constitutes no more than 50% of the reasonable market value at the time of the destruction or damage. So assuming before the catastrophe, a home is valued at, round numbers, $1 million here in Clayton. The cost to reconstruct that is going to be X, but it could not exceed $500,000 to reconstruct that, or this would apply?
So if the damage was greater than 50%, then it would apply. But that would have to be a development that constitutes...
I don't think that's how this reads. At least I read it as saying that the cost of the rehab is no more than 50%. If the building burns down and you have to completely rebuild it, such as some of the folks up in Paradise are dealing with now.
These are the exceptions.
I understand, but my point is, what was the amount 50% based on? Because I did a calculation on what it would cost to replace my house, and the cost of replacing it would be more than 50% if I had to build it from the ground up. And so theoretically, that would mean that the inclusionary zoning would apply to a single unit.
But it only applies to projects that are 10 units or greater.
Okay, so if we were to say that, God forbid, Diablo Ridge burns down, it's right next to the open space, it's conceivable, there's more than 10 units there, that wanted to be rebuilt, and a developer came in to do it instead of individuals doing it, they would probably cost more than 50% of the original or of the fair market value to replace each house. So would that then apply to that neighborhood?
If it were to be, I would think that it would, if it were to be done by a single developer rather than by individual property owners, then it would apply.
I don't know how you would apply it to a development that was existing that didn't have affordable in it already. I think that's problematic. Anyway, before this comes back, I'd like an answer to that question, you know, if we can. I know this has to come back for a second reading, so if we could look at that and the implications and kind of clarify that, because my first thought was, this doesn't compute, and maybe it needs a reference back to all of the above should apply or something like that when you say.
What page in the agenda packet are you on?
It's on page 88 of the packet.
Thank you.
Page 7 of the
89,
ordinance.
sorry, it's top of page 89 of the packet. When you're reading it in a,
Got it.
yeah, on a computer, it numbers differently.
If you have the hard copy, it's page 7 of the ordinance itself.
Yeah. Anyway, it's just a question where I think that section needs to say all of the below may apply or something like that. So just to clarify that would be helpful. Thank you.
Well, the way it's written, A, B, and C are independent criteria.
I
so-
understand, but the answer I just received was it would need to be more than 10
Yeah, that's item A.
for item C to apply.
Well, because item A would be the exception. So if it's less than 10, item A would trigger, and then it would be except as provided.
Okay, I didn't read it that way. And this needs to be in English for the average layperson, and I don't think you're average, Jeff. I think you're probably well above average for that kind of thing. So I just think we need to clarify that so that it's more understandable. Okay, that can come back. And on page 90, I'm looking at, under alternatives, item A6. I was wondering about the potential to add language requiring, if we go this way, understanding that not just construction of the off-site inclusionary units should be completed prior to, but I was thinking maybe occupancy permits. That may not make a significant difference, but I think that's one of those discussions going on at the regional and state level to move to occupancy permits rather than building permits, or a simple word called construction, which is a little more vague, because actually an occupancy permit is when a house is habitable and somebody can actually move in. And obviously somebody could pull building permits but not build. It's very expensive, but occupancy permits is a better way of judging when those kinds of things could be done. And the other question I had was later on that same page under item B, under item B. I don't know where you want to put it, but was there any consideration given to increasing the in lieu fee for off-site to something more significant to encourage building of the units within the same project instead of farming them out somewhere else?
So currently, staff is working with a consultant to determine and look at what the cost of an in lieu fee is going to be. And what staff is anticipating is that there'll be a presentation made by both staff and the consultant seeking direction from council about where the council should really land as a policy decision with regard to how much that fee should be.
And that's what would come back at a later date?
Correct.
Okay, that was just a question I had for.
But I think that parallels with Councilmember Wan's, discussion or his question regarding if someone pays the in lieu fee, are we making any progress towards satisfying RENA?
Well,
And-
exactly.
Right. So what the idea or the policy that you'd be suggesting is we want them to do that on site rather than pay a fee and the unit doesn't appear.
And the way that several other cities are approaching that is by making the in lieu fee considerably higher.
Correct.
So that it encourages and makes it
It's an
more
incentive to do it
affordable.
on-site.
It's an incentive to build it on site. The land use side, the societal side is that really doesn't allow you to isolate the affordable units. It includes the affordable units, which is the whole point of inclusionary zoning, is to mix them in with the general community. Okay, those are my comments for now. Questions?
On item B, though, in the in lieu fee,
Mm-hmm.
it says the developer may elect by right at the developer's sole discretion. But then a little bit later, I think it's changing what it's discussing because it says developer's request may be approved or denied by the council in its sole discretion.
Right.
So what is being elected by right at the developer's sole discretion, and what is being able to be approved or denied at the council's sole discretion?
So for projects that are 10 units and 10 units only, the developer has the right to pay the in lieu fee rather than providing it on site. And then for projects that are
the 10 versus
greater
11.
than 10 units, then that's where the discretion of the council comes in, and they no longer have the ability to request it by right.
Why do we do that? Like, why is there something special about 10 where we give the option and 11 greater than 10 we don't?
I believe it was to give that flexibility because it's not that great of the number of units to really provide just one affordable unit within the development. So if there were 11, then they could provide one on site and then the fractional unit. So that was kind of the demarcation, or the line drawn in the sand, so to speak.
The flexibility that you're referring to is flexibility for the developer?
The flexibility is really up to the city council to determine.
Well, at the 10 unit mark, I'm saying.
Yeah, the 10 unit mark, yes, correct.
Okay.
Any other questions? I have a couple of questions just as well.
One second.
Go ahead.
On that point, would that be part of the policy decision to come back at a later date on the in lieu fee? That decision about by right, 10 or 11, that kind of thing, would that be part of the policy discussion, or does that go with this tonight?
That goes with this tonight.
Okay.
See, the policy discussion later is in terms of dollars.
Right.
Correct.
I'm just clarifying.
So, quick question, or quick comment first on that off-site. If you chose to, or if there's a decision to do off-site units as opposed to in lieu fee or on-site units. So, in terms of the construction and completion of those off-site units, a lot of times I've seen language that says that the off-site units have to have their certificate of occupancy issued prior to the certificate of occupancy being issued for the primary project. So maybe, as Councilmember Pierce indicated, maybe we tie it to that certificate of occupancy. Then I have a quick question about the in lieu fees. So I believe that there's a nexus study that's right now pending, and I think that will determine sort of the pricing levels that we can or can't apply for any in lieu fees. Do you have any sense on the timing on the nexus study or when we might come back on the actual in lieu fee
It'll
schedule?
probably be pretty shortly after the new year.
Okay. And then, as kind of was mentioned, a lot of other cities do have different percentage requirements for when an in lieu fee or an offsite is chosen for the reason of being able to incentivize on-site units. So that's often typical. And I don't think I have any other questions. So unless there are any others.
The in lieu fee is, that's discretionary, right? We don't need to offer it.
The developer can request it of the city, or pay, or can provide on-site or off-site. It's kind of more of a, what is their full proposal? Are they looking to provide a certain number of on-site units and then make up the rest of the in lieu fee? Are they requesting to pay all in lieu? So it would be really up to the developer to ask it, and it would be under the purview of the council to approve or deny that request.
But under this, at 10 units, it's not.
Correct. It would be under the council's purview if they wanted to make that discretionary as well.
But as a matter of law, are we required to offer an in lieu fee?
AB 1505 does require providing alternatives to on-site.
Okay.
And the purpose of the in lieu fee is for the developer then, instead of placing the units on site or building them off-site, is to collect enough funds that would allow the city to build those units elsewhere. So there's a nexus study that will, indicate what is the level of, what does it take to construct those types of units, and then that will allow us to do an actual in lieu fee schedule, which typically then gets increased every year.
So if we collect enough, we could build Creekside?
You could, as a council, the city could decide to build affordable housing units anywhere it chooses. Yeah.
Yep.
Okay, so let's open up for public comment. I have one speaker card here, but if anyone else wants to address this item, please come up to the podium. So I have Brian Budell.
And Mayor, you opened the public hearing, correct?
I do open the public hearing, yes. Thank you.
Thank you again, Madam Mayor. I listened closely to the presentation and watched it, and I'm left with two questions. Why and why now? Both questions are premised on the assumption, and I think it's a pretty strong assumption, that the community and people of Clayton generally don't favor or want any more low-income housing in the city for whatever reason, and also that the proposed ordinance would at best keep it where it's at, but would more likely increase the likelihood of more low housing in Clayton by expanding it. I ask why because I don't see the reason. I don't understand why we need it. As Ms. Gentry pointed out, it was the second bullet point on, I think it was the second to last slide, the city is already in compliance with the housing element requirements for low-income housing. So there's no need for this right now. I understand the idea of maybe staying ahead of the curve and all that, but we don't know what the curve is going to be. The current housing element extends through 2023, and 5 years from now the state could take a drastic change and might decide that whatever is done now still isn't enough. So effectively, by adopting this ordinance, we're bidding against ourselves. We already comply. In fact, we've got a surplus if you look at the statistics of the housing element when it comes to low-income housing, so there's no reason to do this. The why now is, I don't understand the rush on this. As has also been pointed out, this is something that was brought up early last year and is now only coming to a head now, and it's coming during a meeting that's buried 6 days before Christmas without a lot of public announcement. I hate to make the analogy, but that sure sounds a whole lot like what happened with Fulcrum in terms of buried under secrecy and kind of coming in under the radar. I think another concern that falls under the why now is a very legitimate question that was raised by Vice Mayor Pierce, which I was wondering about too, under that hypothetical that if a building is destroyed by, say, fire or whatever and has to be reconstructed, how that's going to apply. I mean, as many of you know, I've only been here for 3 years, but in doing a refi on my house, I was surprised at the amount of increase in value in my house, and that's coupled with the fact that now the demands and costs of construction have gone up exponentially due in large part to the demand caused by the wildfires throughout California. It costs a lot to rebuild right now. So without having that concern addressed, I think passing the bill for that reason alone is a mistake. It sounds very much like we need to pass this bill to find out what's in it, and I think that's a mistake. For that reason, I would urge the council to vote no at this point, seek further clarification. Thank you.
Thank you. Is there anyone else who would like to address the council? Seeing none, we'll close public hearing, and then we'll bring it back to the council for any discussion. Who would like to start?
I will. To address one of the concerns, and staff can feel free to fill in, I think the reason why now is because we do not have a surplus of low-income housing. We have a requirement of 141 units we have to complete to stay in compliance with housing element law by 2022. And we have 10 of those accomplished at this point. We've been assigned 141 units. We're nowhere close to the full amount, and the reason for this would be that if we include rental housing in the inclusionary zoning so that we can offer some of these units at a affordable rate for folks who make, that's not a lot of money when you think about a family of four. 104,000 is the median income. We have more than a few of those folks at that level, which sounds like, 20 years ago that was a good income. It's not anymore. To afford to live in Clayton. And so if we want some of our kids and grandkids to be able to move back here or to be able to rent a home or an apartment here in Clayton, we need to make a certain number of them affordable, not only to comply with the RENA law and with HCD, but to be humane about who gets to live in our community. And we're not talking about people who are not working. We're talking about folks who are actually earning an income and going to be able to contribute to our community. So I think that's important, and allowing rental income to count means that we have a chance to capture more of those 141 units than we currently can by only including owner-occupied for sale units. So I think it does make sense. I tend to think perhaps a higher inclusionary number than 10% makes some sense. I'm okay going up a little bit on that, but I'm also okay staying at 10%. I do think that the in-lieu fee should be higher, and that'll come back to us, I recognize. I think this is good public policy to make sure that as developments are proposed within our town, that they are doing their fair share of trying to provide housing for everyone. And I think that's important. I don't think I could afford to buy my house again. Now that we're retired, we wouldn't qualify. And my kids are struggling sometimes. They need a place to live. I can see my grandkids are probably not going to be able to afford to live in Clayton unless they have extremely good jobs. So I think those are things we need to consider. And including everyone in our community, I think, is important. So that's my comments. Okay.
Well, hold on a sec. So you had said that the requirement for RENA is that we need to actually complete the 141 units by 2022?
Yeah. That's our requirement.
Isn't the requirement that they need to be provided for, but the actual building of the units is not really, if it doesn't happen, that's what?
We have to plan for them. We have to make zoning choices to allow for them to be built.
Yes, I agree.
Yes. And then we get judged at the end of it by how many we've actually constructed and occupied.
Well, we're not doing the construction, right?
No, but we are encouraged to enable that. And one of the things that is being proposed at several levels in Sacramento right now is to take and make your RENA number cumulative rather than rolling it out each time. Up until now, if you had 500 units in one cycle and you completed 10, you completed 10. And then you got a new assignment and started at 0. Now what they're talking about doing is taking whatever is left of your previous assignment and adding to it the next assignment.
Okay, and that's fine, but that's neither here nor there, right? Because that's not the requirement that we're operating under right now. I want to clarify as a matter of law whether or not that the statement that we need to complete 141 units or be out of compliance is true. I don't think that's true.
We have to zone.
We have to provide for them, make them possible, and and whatnot. But it's not like we're doing the building. So I think that as a matter of law, we don't actually need to complete them.
You're correct. We don't have to actually construct them.
Okay, that was one thing I wanted to clarify.
Legally, we don't have to. Morally, we should have that as our goal.
Well, I think that's only if we all have the same morals.
Could be.
So there's only, when we're talking about things that affect only, that this applies to developments of 10 or greater units, I think that in the plan of the properties that aren't considered either underdeveloped or I forget what the name of the category is, but the ones that are vacant, there's only two projects. I don't know. It's the one on Silver Oaks, and then it's the ones near downtown, near the post office, right? Those are the only ones that this would apply to. Do I have that right?
This would apply to any future development projects that come forward before the city.
That's also true. But given that most of the land is either built out or the pumpkin patch has people living on it, we're not talking about that in the foreseeable future, or at least in the short term. So what we're really talking about is this applies to two possible developments.
There are other vacant and underutilized properties within the city. You're correct that we are mostly built out, probably about 98%, but there are vacant properties off of Mitchell Canyon Road, and there's also the Easley Ranch that is underutilized. So there are
and are those
other
targeted
properties.
for because when I look at the housing element, and I look at the realistic units for the housing element, there's a small number that have greater than 10 as realistic units, and those are the ones that we're talking about. That's I'm trying to circumscribe the population of what would be impacted.
The properties identified in the housing element aren't necessarily inclusive of all properties within the city that could be underutilized or vacant. That was just used to plan to demonstrate to HCD that we are meeting our RENA allocation and we have a surplus.
Okay, that's fair. Yeah. So any development that would be over 10 units, this would apply to. Okay, that's fine. I think those are the ones that come to mind because those are, what has been documented.
But what we're also doing, we're not doing this in the context of any single project. This is a citywide ordinance, so you're also setting policy as to whether at a policy level, if we have inclusionary requirements and they apply to ownership units, should they also apply to rental units? I think that's sort of before us and not specifically whether it applies to one project or another. So I think it's setting those parameters as to, is it 10 or more units, which is already in the code? What's the requirement? Does it apply to rental versus ownership?
Okay.
Sorry to interrupt.
No, that's good. I don't have anything further to add.
The rental units that we're talking about are not rental units that are to be built? Or are these existing properties?
It would be for new development projects.
Only new?
Correct.
Unless
their reconstruction exceeds 50%.
Right,
Yes.
I understand.
Okay, so from my perspective, this is a little bit of a no-brainer. On one hand, there's the whole, housing element aspect in terms of we do have to provide a certain amount of affordable housing, and if it applies to ownership, then why wouldn't it apply to rental? But for me, This is also, if we choose not to do anything and if we choose not to apply it for rental properties, I think we are making a policy statement effectively where we favor rental projects. Because by not doing it, by not applying to rental projects, I do think that we are then potentially steering projects towards rental projects. So if that's the council's preference, then sure, we should not apply this to rental housing. But I think, from my perspective, I don't think we as the council should be directing whether projects in our town are rental or ownership. So for that reason, from my perspective, it should be applied consistently to both. Then a couple other comments. I mean, I think the reason why we're doing this now is because the law changed, because we had the Palmer fix. So without the change that became effective in the beginning of 2018, we were not allowed to impose inclusionary requirements on rental projects. So now we are allowed, and now a lot of cities are making the change where they are imposing them on rental units as well. If you think of our inclusionary requirements, applying it to a 10-unit threshold, I think that's fairly common. Using a 10% inclusionary requirement is actually very low. And I think we're starting to see some legislation that is referencing different other thresholds. Senator Wiener just proposed legislation SB 50, which is a little bit different, but in that as well, it's going to apply some threshold, which is yet to be seen what it is. I doubt it's going to be 10%. So 10% is very low. I work in some of the cities like San Francisco that has 33% requirement, which is extremely high. And then you obviously run the risk of that instead of you're really prohibiting development of any kind to occur, because if you price it too high, then projects actually can't pencil out. So you want to find the sweet spot in the sense that you are imposing some requirements so that you can provide for affordable housing, but you don't want the requirement to be too high so that then you discourage development. And in terms of affordable housing, and every time I think we talk about affordable housing, I'm going to make this point. When you look at those income levels that are on the screen, they obviously vary between different areas, but for Contra Costa County, they are fairly high. I mean, if you think about any single teacher in our elementary school or middle school who teaches our kids, I guarantee that there's not a single elementary teacher who makes $104,000, for example. So, when we talk about affordable housing, we're not talking about Section 8. We're talking about people who, as Vice Mayor Pierce mentioned, who actually work and earn a living, but because the housing cost and the cost of living in the Bay Area is so high, that's what we are going after. So I think for me, like I said, it's I don't want to be making a policy statement of favoring rental housing and steering projects to choose to do rental housing so that they could escape inclusionary requirements in our city. So for that reason, to me, this is a no-brainer, and I would certainly vote in favor of applying the inclusionary requirements to rental housing. That's where I'm at, but happy to hear where others are at.
All right, I'm not sure that it would steer that way. I think it has the potential to do that.
I will tell you from practice, working with a lot of developers, what your affordable housing inclusionary requirement is and how you can structure it absolutely impacts how you pencil out at the other end.
Oh, yeah, for sure. It'll affect the economic viability. Has that been tested, what the number is?
It depends on the jurisdiction. I know in San Francisco they've had economic studies done as to what is the right level. So currently they require 30% at the highest level if you're doing on-site, 33% if you're doing off-site or in new fee. And the city's controller had said that the sweet spot in San Francisco, and I'm not sure that it applies directly on us, but it's between 18 and 20% approximately. So that if you require anything more than 18 to 20%, and they do distinguish between rental and ownership being a different requirement, that after that you are discouraging development, that you start hurting. And San Francisco is seeing it in practice right now, where because the inclusion requirements are so high, projects on pencil out, they are not moving forward. They have less residential applications, so it is actually impacting in that way.
So in the rule, it says something like if you have greater than 15% requirement, then I forget what the acronym for the agency is.
It's HCD.
HCD has the ability to do stuff like question whether or not you're in compliance and whatnot, but you can rebut that inquiry if you are essentially in compliance with your housing element, which we are, and that you provide the number of units, which we do. So do we see a risk if we were to exceed 15% of undertaking some onerous burden?
That's the feasibility study that
correct.
Tuya was
Correct.
referring to. And if you were not producing the number of units that you have zoned for, and you have a very high inclusionary number, they could request a feasibility study to see if your number is impeding development.
And if it is,
And if it is, they could require you to change it.
do we pay for that?
Yes.
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 But couldn't we rebut it if we meet those? There's two triggers, if I recall correctly, where they could request this, but we rebut it with these two things that we satisfy. I don't remember the language. It's something like we're in compliance with the overall policy and we have the number of units. Is that something that gets done without the study?
So if the city requires more than 15% of the total units to be affordable at households at 80% or less than the area median income, then it could trigger basically HCD's review of the city's inclusionary housing ordinance, but it only has the authority to do so if it meets the two triggers, which are, the first one is that the city has failed to meet at least 75% of its share of the RENA for above moderate income households over at least a 5-year period, or the jurisdiction has failed to submit its housing element progress report for at least 2 consecutive years.
So
and the last one, we're in compliance and have submitted every year.
Are we in compliance with the first?
No, we've only constructed 8 out of the 34.
I have to do math. 4 is 25%. Okay. Ish.
Can I ask where you're heading with that?
Just exploring what the limits are.
Well, for the
How many we
purpose
would
of,
have to construct to still stay within that?
Yes.
Yeah. I mean, if you were to go 25% of the 140, then if you hadn't completed that number, they could require you to change.
Well, it's 75%, you said, right?
I'm sorry.
Did you say 75%?
75% of above moderate?
So
Of the above moderate only.
Correct, yeah.
So we would need a lot.
Yeah.
So an additional 18-ish. Right?
so I understand. So are you asking the question,
So if we were to have 18 or whatever, over 75%, and we've met the other requirement of being submitting our thing in compliance for, not submitting it for more than 2 consecutive years, then we could establish a super high percent of inclusionary housing and be fine, right?
so what's your what's your goal of trying to have a really high affordable housing requirement so that nothing gets built?
No goal, just exploring what the limits are of what's allowable.
I mean, you could impose a 60% requirement or
Sure,
whatever. So
but then we would be
the
subject
reason?
to this inquiry.
Right.
Okay.
But are you trying to achieve something by having an extremely high?
Well, it seems like the percent is discretionary, so I'm trying to determine what would color our decision-making around what that percent should be. So exploring what the possible outcomes are is part of determining what the population of choices are.
Yeah, I mean, typically I think you would do a feasibility study to say where the appropriate level should be, but obviously that would require the council's decision to spend money on a feasibility study, and I don't know that that's some money I guess you'd have to allocate, but I mean, I think you can impose a requirement and know that you're you certainly, I don't want to use the word safe level, but in level that's consistent with other jurisdictions. So
The 10% would
Without
not
testing
cause alarm or
Right.
red flags.
I mean, it
so
seems
to
like
speak, under
15%
HCD.
is the demarcation point, right?
HCD has identified that statewide, yes.
So where are we as the council on, I've certainly indicated I'm supportive of applying it to rental housing, but what am I hearing?
I am as well.
I'm opposed. I think I'd like to, on the ordinance as it's written now, I'd like to eliminate the that 10-unit line item that gives developers an option by right to do something. I'd like to eliminate that. And then also, I guess, we are required to provide for a certain number of inclusionary units, and we have a choice on how we do it. I think if we have to choose between funneling those units towards development for owner-occupied versus for rent, I'd prefer that to go towards owner-occupied. I think that creates greater stability in the community. Plus, I think it incents more investment in the community than a rental property does. And so for that reason, I think if we are to be required, as we are, to have inclusionary housing, then my preference would be that inclusionary be funneled towards owner-occupied properties.
But don't you think, so let me just ask you a question, because the way I look at it, if we don't apply it to rental housing, that means that the developer could come in and look at, okay, I got a 10-unit project. If I do ownership, I'm required to do one inclusionary unit, meaning my profits are going to be lower. If I do a 10-unit rental project, I'm not subject to the inclusionary requirements. Therefore, I'm probably going to make more money. So don't you think, from my perspective, if you don't apply it to the rental, you are steering development towards rental. To me, it's completely the opposite. And I don't want to make that decision. I don't want to necessarily steer projects towards rentals as a policy matter.
Yeah, I guess I'm just not convinced that it does that. I think because, in an environment where you had a lot of available choices or a lot of places to build, I think that's probably what would happen, what you're saying. But given our fact pattern that there are so few places that we're talking about that are potential for rental properties like this that are over 10 units, I don't think that's going to be an issue in our circumstance. The existing proposal that is deemed complete is already a rental development. So, and it already meets this at the 10% level. It probably wouldn't meet it at the 15% level. And the Silver Oaks project is a owner-occupied development, if I recall correctly. And so there's very few other places that are immediately come to mind as being potential for these type of things. So when we're talking about funneling, I think, if we were in a city that had a lot of development potential in lots of places, then yes, but in our case, I don't think that's true. So if we are to encourage it, I would rather have those requirements be met for owner-occupied places. And the other piece, like I said earlier, that I'd like to strike the part where that gives the developer by right at the 10-unit level. I'd also like to explore a higher percent as well, at least at a minimum up to the 15. At least, and I just want to see what that does. I'm not necessarily saying that I'm in favor of 15%, but I want to understand what that means more. So I'm not there yet on that one. But as it stands now, that's my take on it.
So I would note a little, one thing is, when we do citywide ordinance, like I said, I don't think we're looking at one or two specific developments. You are putting in place a code that lasts for 5, 10, 15, 20 years until you change it. So I don't think that just because you can't foresee a development today or tomorrow or 5 years from now that you can make a decision on that. I think you're looking at a citywide policy as to whether at a policy level, in this case, inclusionary requirements should also apply to rental units.
Yeah, these things don't sneak up on us, right? Yeah, this will last until we say it doesn't. And so at that time, it takes 2 meetings to change it.
But as a city policy matter, the minute you get an application in for something, do you quickly go and scurry and change your codes? I don't think that's good planning either. I think you think about these and you think about, okay, what's the right type of zoning and what's the right type of development controls for our city, and you do that. And instead of changing them per each project.
Well, yeah, I wouldn't suggest changing it on a project-by-project basis, but I think as the fact pattern is now and for the foreseeable future, that assessment would still hold. If it doesn't hold, then, we have a new fact pattern, we'd change it.
I think we have several properties that are already zoned as housing opportunity sites with a higher density. We have the corner of Mitchell Canyon and Clayton Road, which I think at one time in the fairly distant past, we looked at a potential for somewhere around 20 units on that.
Is this the fire station?
Yeah, the old fire station. Mm-hmm. And that property has amalgamated at least one extra property to that, I think, adjacent. And who knows what could be proposed there. The original proposal that we got back in the 90s sometime that never went through was somewhere around 20 units, if I remember correctly. And then there's the Easley Ranch, which is huge, and it's zoned for multifamily high density, right?
No, it's actually zoned for single-family low density.
Single-family
low density, yes.
Okay. But it would still fall under the discretionary, and it could be quite a few units, right? I mean, the inclusionary?
Given the makeup of the density designation, it would probably more default to home ownership or for sale, but it would definitely trigger more than 10 units.
Mm-hmm. Okay. I'm trying to think of which other properties we've got that we've got the Silver Oaks one, which could, I mean, it's not in process yet, right?
Silver Oak Estates has been in process since 2010, and
they
are aware of the city's of requirement for
But
affordable
it's been
housing
sort
units.
of ongoing, changed every 5 minutes, so, or, 5 years, whatever it turns out to be. It's been lingering for a while, and they could easily decide to go rental instead to avoid the inclusionary, right?
I think that would be a little bit more difficult because it is also single-family detached for a medium density at that location.
But that's presently, though.
Yeah. I mean, the current drawings are what, seven
plan
single family and like
Yeah.
51 townhomes?
Is it 48 townhome? Something like that.
I don't even remember what it's been changed to since we changed the sensitive land on it, and we decreased the amount of buildable property.
It's hovering around, there hasn't been a formal submittal, but discussions with the developer, it's hovering around 32 units.
Okay, so that could easily wind up being a rental project.
It might be a little, I mean, if they decide to keep title of all of the, because it's going to be a tentative map.
Mm-hmm.
So they would have to remain, keep title to all of those rather than sell them individually. But there are
It would have more hurdles than it does right now if it were to go to rental. I mean, they'd have to, it's not contemplated currently as a rental development.
Right.
Okay. I just don't see the upside of leaving rentals out of the picture. It seems to me that it does make rentals cheaper to build than ownership properties, and I don't know that we want to encourage rental developments versus for sale units. That's what I'm hearing people say, and I don't see why leaving this restriction off there is going to do that. The by right question for the developer for the under 10 units, is that something that we're required to do by law?
In regards to the payment of the in lieu fee no, that is not a requirement by law.
So we could amend this ordinance to make everything come to the council as discretionary?
Correct. The only caveat currently drafted in the ordinance is if they are meeting the prescriptions that would be passed by the city council resolution and what's highlighted in the ordinance, would my position have the ability to approve an affordable housing plan? But if there's going to be approvals already required, then more than likely staff is not going to make that decision. It's going to come as a whole
But that would
package
mean
to
that all projects would have to come to the planning commission and council for decision, right?
Correct.
Okay. Which technically slows the project down. It's counter to streamlining, certainly, which is something that developers are looking for. So it adds to the cost by doing that. But that's something that, were we to choose to introduce the ordinance tonight, could be incorporated if we chose to do so in the final, or would that have to go to, would it be better to continue this to another meeting before introducing it? To see if we can amend it to fix the things that people are concerned about.
I think based off of the suggestions you're making, we could make those revisions and bring those back to council for
the second reading?
Correct.
Okay.
If there was the desire.
What controls whether or not you can
The significance.
make it the significance?
Yeah. If it's substantial, it would require the planning commission to consider the changes if they didn't already consider them.
I see. Would changing the percent trigger that?
Yeah, I do believe changing the percent would.
All right.
So is it my understanding, Councilman Juan, that you will want to have some fine tuning done to this ordinance before we have the second reading? Is that correct?
Well, I mean, if it were to pass, then I would want the fine tuning.
Well, it's not passing tonight. It's just the first reading. There'll be an opportunity for if you wanted to work offline with the staff to kind of fine tune and get those specific and concise pieces that you're looking to include for consideration.
Can I have our city attorney?
Sure. I think the comments that have been made today, if that's the pleasure of the council, we can work with those and bring those back to a subsequent meeting, and you could consider adopting it at that meeting. However, I wouldn't recommend making additional changes offline. So if you have additional comments or concerns,
I'm not suggesting that we do it offline. It was just a comment. But my point is that is it going to come back for another first reading, or will it be the second reading?
I think we can bring it back as a second reading.
Thank you.
But not if it changes the percent of inclusionary.
Correct.
Okay.
If it's I think the comments that I've heard, which is to modify the 10 to make it not by right, but by discretion, and then clean up the section to make it clear that a single family home that gets reconstructed isn't going to be implicated. I think those kind of changes, we heard you, and we can bring that back for your second reading.
Occupancy permits versus.
Exactly, an occupancy
Yes.
permits.
Okay.
Exactly.
Versus construction.
Yeah.
Raising the in lieu fee, all of this.
Well, the in lieu fee dollar amount is a separate matter.
That'll come back later.
And we need the nexus study.
Yeah,
before
this
we
just
can do
says
that.
we get to establish it, but not now. So, are you all good with 10%? I can ask that, right?
Mm-hmm.
Right.
I'm okay with 10%. I kind of think 15 might be better, but we're probably more likely to get stuff built at 10%, so.
I think the question becomes what's best for the investment in the city and what's best for us as a city. I'm not against the 10%. I agree that 15% would probably be a passable number. I think we have to look at this as getting to that, as close to that 141 as we can. And does this do that?
Well, would you be in favor of a greater than 10% number in order to satisfy the moral commandment, or is it a way to make it so that the projects become less economically feasible?
Well, I'd like to see the number be set to make it economically feasible.
So the first one.
I don't think that for me, it's a moral requirement or a moral commandment. I certainly feel for the people that won't be able to live in Clayton, your kids later on, who knows, and all of this is really a hypothetical reach for now. I think we just have to come to some conclusion amongst ourselves as to what's the viable number, and come to some agreement that number will work for us. So if it's 15, I'm fine with that. But I don't think it's a moral commandment. I think it's just something we have to figure out what is the best economic value to the city. And are we going to get to that 141 in time? And what are the consequences if we don't? Again, hypothetically.
Well, again, a number of the 141 are met with properties that people live on right now. I mean, we're not going to get to the 141. We're going to provide for it and zone for it and allow it if it were to come before us. But we're not going to get to that number unless a whole bunch of property vacates, right?
Sure, of course.
Or we have a swarm of ADUs go in.
True. So,
not yet.
Two doesn't make a swarm.
It's not before the planning commission.
I do think, as a matter of principle, I tend to be opposed to intervention in this manner, and to the extent that we can minimize intervention in market forces, I would prefer it. So, and on that regard as well, I don't think that I would support that. I mean, if we were to move forward, I would definitely want to make those changes to make it more amicable. But I mean, overall, that wouldn't be my intention if I were to have my druthers.
So what would the intention be then? So I'm clear.
I would be opposed to including it.
Opposed?
Yes, I'd be opposed.
Without any
But if we were to move forward, then I would want to have those other items fine-tuned so that it makes it better than it is now.
But I think if your justification is that you don't want to interfere with market forces, you're doing exactly that by not imposing it on rental housing. Because if you have a developer who has a choice of not doing inclusionary housing by amending the housing type, I guarantee you they're going to choose, unless it's like a single-family project. But if you have a multifamily project and they can make more money out of it because the city has made a decision not to require inclusionary housing on rental projects, I guarantee you in a lot of cases you will find rental housing. So I think you are interfering with the market if you choose not to apply for rental projects, in my opinion.
Yeah, I mean, the only thing that gets impacted that's on the table now is we lose, I mean, you go from the 5.9 and it would go up to what? 9 or something if you go from 10 to 15.
Well, I mean, so we're not talking about a specific project, but in order to utilize the density bonus law, I think they're getting to their whatever affordable housing requirement by doing certain levels. When you use the state density law program, there are different affordability levels, AMI levels that you can choose, and the percentage requirement is different. So if you do very low income units, you can only do 11% of that. If you do moderate income units, you can do 20%. So they can restructure their program and just by changing the affordability level of those.
And still have the same number.
Yeah.
So I guess my question to you, Jeff, is are you trying to encourage housing or discourage it? I think that's what we come down to with this.
Which vote would you say does which option?
Well, you said you don't want to interfere with market forces at all. So if that's the case, are you wanting to discourage new development?
Well, in a matter of a yes or a no, do you believe that one choice encourages and one choice discourages?
It's a matter of which type. I mean, Tuya's right. If you allow rental housing to go without inclusionary requirements, you're encouraging rental housing on all of those sites where it's zoned for multifamily. I mean, it's just an economic choice. But if you make it equal, That's one thing. That's a level playing field. It's going to depend on what the developer wants to build, what pencils for them. If you increase the inclusionary percentage, you're probably going somewhere toward discouraging any development because it's more costly. It takes more to pencil. The higher the inclusionary number, the more it takes to pencil, the less likely we are to get actual development. So if the goal is to prevent development, then make it 25%, and it won't happen.
I think that
we would run into other hurdles. If
Yes, we would.
And I think the point here too is that, we're living in our tiny little bubble here in Clayton, but there is a lot of push coming from Sacramento in not allowing us to make any of those decisions in future development. And I was listening to one senator about 6-9 months ago, how he wasn't happy how the RINA numbers are allocated to different cities, how that system should change so that we're going to end up getting higher numbers, essentially. So there's a lot of pressure coming from Sacramento. So we can do whatever we want, but ultimately, at the end of the day, the number of housing bills that are getting introduced in Sacramento and the types of personalities and people who are pushing for those, we're going to be more and more constrained. So.
Yeah, I mean, I grant that that's probably true. I don't think that really influences what we do right now. I mean, whether that happens or not, that'll just happen on its own.
Yeah, but it factors into the thing. If you are making a decision to not apply inclusionary housing to rental project, you are effectively encouraging rental housing, and the next whatever number of projects or whatever those are, they might choose to do rental project for that reason alone, which means you are not meeting some of your numbers potentially, although you're building some housing. And then if there's changes in Sacramento, yeah, you could absolutely have made your bed in some ways based on the decision you're making tonight.
Yeah, and that's why I was asking earlier about whether or not you could favor development, if that could be a tool to favor. But
well, you can't choose between a rental project and a for sale project. If a developer comes in with one or the other, you can't say, no, I want the other one. But by making the playing field level and requiring any development to have the same level of inclusionary zoning on it, you're at least keeping it as a level playing field and not favoring rental over homeownership.
if you were to have a disparity between the percentages, then you think that it would further discourage rental over ownership? 15 versus 10 at 1?
It's going to discourage development altogether. The
If you
higher
have
you
15
go.
at rental and 10 at ownership, are you saying that you would encourage owner-occupied then over the other?
To some extent, I think you need a feasibility study to figure out exactly where those push points are. And you'd have to do a pro forma on a specific project to see where does it fall over on this side or that side. So, I mean, there's a whole lot more financing that goes behind it than I think any of us can say it right now.
I don't know if we're allowed to give, can we actually determine a different level of inclusionary for rental versus for sale?
We can.
I would wonder just what the rational basis is between doing.
How we would justify that.
Correct. And if it's some study to document it, I think that would be there. But if we were to just do it, I would question.
The level of scrutiny rational basis?
It's the lowest, but I haven't heard why you would do it, other than if the incentive is to not encourage.
Well, those of lesser means would be more apt to be able to rent versus buy. So if you had a higher percent required for lower income at a rental property, you're more likely to fill it because of just the nature of income and savings and what it takes to purchase. I think that satisfies a rational basis.
So you're trying to, is the issue then you want to promote rental housing?
If you want to satisfy a requirement, that would be a rational basis. I mean, I can make that argument.
That's what I would want to hear from the entire council, and I'm seeing different looks. So that's the question I have, is I would just want to make sure that we had on the record a real basis for why we're distinguishing between for sale versus rental.
So you said if you had a higher inclusionary for rental?
Yeah, it's recognizing that those of lesser means are more apt to be able to rent than buy. And so that you're encouraging those folks to enter the city via those units.
But you might be discouraging the development of them in the first place.
Yeah, excuse me, that's a post-construction consideration.
Right.
Versus a
But
pre-construction.
trying to get them built, it would be discouraging them because it would cost the developer more per unit to build them.
That's also, I think that's also true.
So that actually discourages building rental.
That may be true, but I think the rational basis standard allows that level of disparity between those two competing interests.
I don't see that one.
So what's in front of us today? So obviously, I think there's been a couple suggestions for a few amendments that would come back next time. Obviously, the council could, even at that point, I guess they're minimal enough that we could do a second reading next time and pass it. But obviously, if the council still wanted to noodle it,
level.
right, at the 10% level, it could still get continued for another second reading, essentially.
Right, if you were to introduce it tonight,
Okay.
then based upon your action to cancel your January 2nd meeting, it will come to you on January 15th. You can have additional dialogue, and at that point in time, you have full discretion whether to adopt or amend it.
Yeah.
Then you would have
table
to
it.
introduce it again,
Correct.
and so, correct.
You could introduce the new one at the January 15th meeting, correct?
If we agendized it
Right.
properly.
Yeah.
I mean, I think that may give a little bit more time for it to marinate, in that given the timing of this meeting and that this is, a week before Christmas, and that folks may not have had sufficient time to digest what is happening, and given the nature of some of the changes that we're talking about, if it's an option to table rather than introduce at this point, and then we can come back at the 15th meeting with the changes in hand.
Well, I think
I would
what Mr.
recommend you
Natcher
actually introduce it, and it would come back at the January 15th
second
meeting.
reading
For the
and
second reading. And then you guys could decide if you wanted to adopt it, or if you did want to make additional changes, we could agendize it accordingly, so you could
But
reintroduce it.
alternatively, you could continue the public hearing and not introduce it tonight, and that's what Councilmember Juan, that's the procedure that you're talking
Yes.
about. That's how to accomplish that.
And because I think the question of 10%, and that would trigger it would have to go back to
We'd
Planning
have to-
Commission?
Exactly.
I think that kind of starts it in a process where folks may be aware of the issue on the table. If you said that you are open to the idea of a different percent, you said that you're open to the idea of a different percent. I think that's something that may be a good idea for Planning Commission and other folks to weigh in on what they're comfortable with at what percent. Seems like something that can be discussed by folks of interest, especially when we're not, a week out of Christmas.
So I would probably be inclined, I think we gave some feedback to staff, at least, I don't know where everybody is, but to have the introduction today, to have staff come back next time with some of those amendments we discussed, and then make a decision whether you want to, make further amendments, whether you want to send it back to the Planning Commission for anything more substantial, but at least you have the option at the January 15th meeting.
And that we're not precluded from that.
No,
No.
we can do that.
Yeah, we could all vote in favor today, and then vote whatever the opposite of that is at a later date.
Are we talking about continuing the public hearing then?
No.
Or not?
If you continue the public hearing, you would not introduce the ordinance.
Right.
Okay.
And the reverse is the same.
It does not mean that we couldn't take public comment
Correct.
at the
That means
next
there's no more
meeting.
public hearing then?
There's always the opportunity for people to comment, and it would be under the action items of your agenda.
I see. Okay.
The public hearing aspect of it gets into notification in the newspaper.
But with it being an action item, then we have a decision as to whether we want to finally adopt it on that January 15th, or whether we want to make further changes, send it back to the Planning Commission or whatever. So it keeps the option open at least. And then we'll have some revised language in front of us at the January 15 meeting that
Right.
we will have had a chance to look at ahead of time.
And if we wanted to, we could say, don't do anything. I mean, we have that option of taking no action at all.
And again, just from my clarification, if we do no action, what's the end up of that?
Then inclusionary requirements will not apply to rental housing. The ordinance stays as it is.
Stays as it is,
Yeah.
okay. All right.
Yeah. So you closed the public hearing, correct?
She did.
It did, yeah.
Yes. So I would move to have the city clerk read ordinance number 484 by title and number only and waive further reading.
Is there a second?
I'll second that.
This is just so that we don't have to read the whole thing out loud.
Yes.
Right. Unless you want to be here until midnight.
You don't want to read the whole
Till
ordinance.
next Thursday.
Just want to make sure I got the right one.
Yeah, what Councilmember Juan is indicating is it needs unanimous vote to read it by title and number only. Otherwise, our city clerk would
Has
be
to
the
read
lone
the whole.
person here reading the ordinance while we all go over to Ed's or whatever and then come back.
So on that motion, everyone in favor, please say aye.
Aye.
Anyone opposed?
And that I vote, for further clarification, does not compel you to vote yes for the introduction of the ordinance.
Yes.
Great.
Ordinance number 484, an ordinance amending chapter 17.92 of the Clayton Municipal Code regarding inclusionary housing requirements.
I would move to approve ordinance number 484 for introduction to amend the Clayton Municipal Code, Chapter 17.92, inclusionary housing requirements for the purpose of including rental housing projects into the local housing requirement as allowed for by AB 1505, zoning ordinance amendment 0218, and as amended this evening.
Okay, is there a second? I will second that then. So on that motion, everyone in favor, please say aye.
Aye.
Anyone opposed?
Me.
Okay, so it is,
Announce the vote, please.
so 4-1 with Councilmember Juan opposing. And that's it. So we will move on to our next item, which is item 8A, which is an action item, although I think it is merely an informational item regarding the presentation of the city's financial status report regarding its public employee pension system provided through through CalPERS based on the latest actuarial data as of June 30th, 2017. We have our finance manager, Mr. Mizuno, please.
Thank you, Mayor Catalano. So each year, the city's pension administrator, CalPERS, publishes an updated actuarial report for each of the city's plans, 6 plans that we have. And the most recent ones were published in August 2018, dated June 30th of 2017. And those provided the ARC, or the annual required contribution, for fiscal year 2019-20, which is next fiscal year because we're currently in 18-19. So the purpose of this now annual staff report is to provide an update on the city's pension plans and the fiscal impacts thereof to demonstrate accountability, transparency, and responsibility. I think there was heightened awareness of the situation that several California jurisdictions were in after the Great Recession in approximately 2008. So several actions were taken by the local city council, the state legislature, and CalPERS to address those matters. And because of the heightened sensitivity with that back then, approximately 10 years ago now, The city council had directed the city manager and thereby staff to provide an analysis or an update on where we stand annually once these actuarial reports come out, are published by CalPERS. So a brief background is that in lieu of Social Security, the city of Clayton has participated in the California Public Employees Retirement System, or CalPERS, since July 1st of 1975. So several measures, 5 measures have been taken to address the city's exposure to pension expenses, which are outlined in this current slide. The first being that the city proactively established a second tier in 2011, which resulted in essentially the closure of the original first tier to any new members. Even, for instance, other jurisdictions have policies where if you don't have a 6-month lapse in service working for a CalPERS entity, you can still go in under the classic plan, which is why a lot of jurisdictions ended up in the situation they were in. And the city council at that time opted to already create a more affordable tier for the city, and that was in 2011. Thereafter, in 2013, the state legislature adopted PEPRA, or the Public Employee Pension Reform Act, and that essentially created a third tier, which is the latest tier that we have now for all new members to go into. And that's even more affordable than the second tier that was created in 2011. Thereafter, CalPERS reduced the discount rate, which is the assumed long-term investment return rate, from 7.5 to 7%. And that was smooth over a three-year process from fiscal year 2019 through fiscal year 2021. So the current year is our first year of that slightly reduced discount rate. CalPERS also implemented a fixed dollar unfunded actuarial liability payment process, or what we call as the UAL, in fiscal year 2016, or 6 years ago. And we're going to get to a slide that kind of summarizes the short and long term impact of that action. Finally, the city in fiscal year 2018 established fiscal year 2018 was the prior year, established a pension rate stabilization fund, which is an internal service fund, and that acts as a hedge against ARC contribution hikes caused by any market fluctuations or actuarial assumption changes approved by the CalPERS Board of Directors. So these CalPERS reports are published annually and made publicly available on the CalPERS website at www.calpers.ca.gov. So the following slide provides a summary of the existing plans that the city has that I briefly discussed in the prior slide. And essentially there's 6. There's the first tier is the classic. We have, of course, our safety, our sworn police officers, which we have 11 of them, which includes the chief of police. And then we have our miscellaneous members, which is essentially any other full-time employees or full-time equivalents thereof. We do have 2 employees at the city that are 60% full-time equivalents. So essentially they work 3 days a week, and their benefits are prorated, and retirement is prorated accordingly to 60%. Then we have a classic tier 2 tier, which was created in 2011, and then we have the latest PEPRA class. So approximately right now, as a statistic, 56% of the city workforce is in the third PEPRA category right now, and essentially the classic is no longer growing. It's decreasing as we have attrition through retirements or lateral movements to other cities, and then classic tier 2 hasn't really seen any significant growth since the adoption of PEPRA. This slide provides a summary of the various contribution requirements by each of the 6 plans. So there are 2 types of employer contributions, which it's important to distinguish against those. We have the normal cost pension contribution, which is the old way of doing things. There used to just be a normal cost, and that's essentially a percentage of payroll methodology. So for each dollar of pensionable income earned, there was a rate that was approved by the CalPERS board that said the employers were required to contribute that amount annually to the plan. Thereafter, in fiscal year 2016, CalPERS also created the UAL fixed dollar contribution, which I believe the next slide will kind of summarize why, to address the increases to the unfunded status of the classic Tier 1 plans. I think the most important thing to note, just looking at the comparison table above, which shows the current fiscal year of the rates and contribution requirements, which are statutory, compared to next year, is that the largest increase was noted in the classic Tier 1 category for our sworn police officers, which was approximately 26% from the current fiscal year to next fiscal year. And that large spike is actually mainly due to savings we realized in the current year. You can see the UAL payment, fixed dollar payment, is about $125,000, and that's because of the payoff of the Tier 1 safety side fund. So we did realize some savings in that, and then of course it goes back up, and then it climbs, which we'll get to in 2 more slides, for a few more years, and then it begins to amortize downwards over the long run. So this is the slide I referred to a few times, and some of the council members and members of the public should be familiar with this, as it's always included on our proposed budget annually. And it essentially shows a historical illustration of the past 10 years of citywide pension contribution costs and our internal projections for the next 5 fiscal years, which includes the current fiscal year, because there's of course uncertainties because it still hasn't concluded. So as we can see here, from fiscal year 2012 to 2015, the city and actually I would say most California jurisdictions participating in CalPERS did see substantial savings as our classic Tier 1 employees were retiring or moving out and going to other cities and being replaced by these Tier 2 and then PEPRA employees, which were more affordable, of course, at the time. So CalPERS realized this, I wouldn't say quickly, over a few years, and that's why in fiscal year 2016 they established a fixed dollar contribution amount, so in addition to the percentage of payroll, because they weren't collecting enough for the Tier 1 employees on a percentage of payroll method, so they said, well, we need to establish this to address these unfunded liabilities. So then in fiscal year 2019, which is the current year, we see a projected dip in employer pension contributions of about $64,000, which is pretty substantial for a city of this size, which was due to the payoff of the classic Tier 1 public safety side fund. Then in 2 years, we are going to see, after the spike I talked about previously for next year, we're going to see a minor decrease again because of payoff of the Tier 1 miscellaneous side fund. And those are non-recurring, and of course, we're always wondering in the long run, are we going to reduce these over time? And the actions that were taken in the second slide, those 5 items, the intent of those was to address it in the long run. And actually, the CalPERS has created they have created a 30-year amortization schedule for our unfunded liability, so it is projected to be 0 30 years from now, because if we were to pay it off immediately, we simply don't have the funds to do that currently. And as the finance manager of the city, I wouldn't recommend that action to the city manager nor to the city council as a good use of funds, because we certainly don't know if CalPERS is going to change the discount rate next year or the year after that, and then suddenly we have no emergency funds for a landslide or a fire or anything of that nature. So this is an interesting slide that just summarizes the full amortization of the Tier 1 side funds for the safety and miscellaneous plans. As you can see, it was pretty substantial in prior years for public safety, and it is effectively 0 as of July 1st, 2018, which is great news going forward. And then in 2 years, the Tier 1 miscellaneous side fund is going to be fully eliminated as well, or paid off. And there is a little bit more discussion in the staff report about what the side fund is. Essentially, when over a decade ago when CalPERS mandated that all small employers, so any participating employers with less than 100 employees, so any agencies with less than 100 employees, they weren't allowed to have their own plan, and the legislature saw that it would be effective to pool your liabilities and your assets together, to get, I guess, economic efficiencies out of that. So when cities and jurisdictions were mandated to join this pooled cost-sharing plan, they essentially created side funds. So if your benefits at that prior to being pooled were higher or lower than other jurisdictions, you would either get a side fund liability or a side fund asset, and those would be amortized over time, which that now they're coming to their end. So that's good. That will result, has resulted and will result in some savings in current and future contributions. So this final slide is a historical trend with long-term projections. So it's essentially a summary of the Tier 1 unfunded actuarial liability, or UAL, obligations for past, present, and future. And the reason this is only summarizing the Tier 1 plans is because really the Tier 2 and the PEPR plans don't have anything material to really bring up at this point, because they're operating as designed, because they're more affordable to the employer, and the employees need to contribute more into these new tiers. So what this shows is the Tier 1 UALs were initially published by CalPERS for cost-sharing plans in fiscal year 2011. So I annually will include whatever the actual amount is in the spreadsheet to show any changes and spikes in that. And then they also show where they anticipate these UALs to go over the long term. And both of these UALs are projected to be fully amortized to zero after 30 years. So some of the changes to note in this is that as of 6/30 of 2017, CalPERS posted a return of 11.2%, which exceeds their discount rate at that time of 7.5%. So because of that, we see a decline in both of the UALs, which is good news, that we beat the long-term rate. And then again, this year for June 30th of 2018, CalPERS again posted a positive return of 8.6%, which exceeded their discount rate of slightly less than 7.5%, because they had already reduced it over their 3-year phase-in at the time. So as of right now, in the latest actuarial reports, we can state that the funded status of both of the Tier 1 plans has improved. So the public safety Tier 1 is now at 74.9%, and the miscellaneous UAL is now at 74.7%. So both of those UALs did improve. Now, of course, we do see the Tier 1 UAL for public safety increase a little bit before it declines, and that's likely because they reduced the discount rate on us. So anytime CalPERS is going to say, well, you know, our long-term projected rate of return is going to be less, they got to make up that income from somewhere else. So if it's not coming from the market, it has to come from the employees and the employer. There's no other place for that to come. So that's probably why that is. I'd have to have a professional actuary provide input on that. But then, of course, it does decline. So that kind of summarizes just our status right now. This is an exercise we do every year. They usually publish the reports in August. Right now, it looks like it's headed in the right direction. We do have that internal service fund to help against any hedges and any spikes in contributions going forward. I don't see that we are going to need to dip into that next year based on the projections. But in future discussions, if there is excess available, we can always recommend or take advice from the City Council to add to that or use from the internal service fund as the Council and the City Manager see appropriate. So that concludes the report, and I'll send the matter back.
Great, thank you very much. So since it is an informational item, there's no action on our part, so unless there are any questions of staff, anybody would like to ask? Go ahead.
I know you talked in percentages, but based upon the actual numbers, how many public safety is there? 11? Is that all there is?
Yeah, we have 11 sworn officers.
Okay, what about on the other, the miscellaneous? How many total?
We have, just a moment here.
15.
Okay, so we have, currently we have 27 full-time employees at the city, and 2 of those are 60%. So out of those 27, 11 are safety, which would mean that 16 are part of the miscellaneous group.
All right, now back to the smokestack presentation you had on page 5. Help me understand the difference between the green numbers and the red numbers. Good and bad.
Let's see.
That's my question.
Oh, yeah, sorry, yeah, it's on here it's 20, just to clarify for the audience, because my presentation was added to Mindy's, but on the printouts, it's, my page number is 5. I believe Councilmember D is 20 is 5. So the blue.
Okay, mine is 5. So
yeah, mine is 5
right.
too. It's just up on the presentation for the public to view. So the green, yes, you're absolutely right. Green is good, meaning the contributions, the projected pension contributions are going down, and red is bad. It's going up. Anytime it goes up, I consider that bad.
Okay, so the years 19 and 21 are basically in better shape than 20, 22, and 23.
Correct.
Okay.
Correct.
It represents the delta from the prior year.
Yeah.
Okay.
You know, and to say good or bad, you know, the short answer is, the simple answer is, to me it's bad because it's going up, but when you think about in the long-term perspective, with inflation, things it may go up just $1, and I'll still have it be read as bad, but it's good that it was just $1. So as you know, over the next 20 years with inflation, as the economy changes locally and regionally, incomes could increase, and we could see increases. But as long as those increases are controlled and low, then it would be red in the slide, but it still could be a good increase.
Thank you.
When you said that there's 11, does that include all the historical members of the pool, or I mean that's just the current population?
That's current employees.
No, those are active employees. You're talking about retirees?
Yeah, I mean that we incur a cost there too, right? So.
Yes. So for the retirees, our contribution requirement for them is basically built in to the fixed dollar UAL payment from CalPERS.
Okay. What do we contribute to the pension stabilization fund on a regular basis?
We have been since it's been established. It's about 2 years old.
2 years
yes.
old. What's the rate?
The rate that we contribute?
Yeah, the amount.
Well, right now it's what, 167,000 some odd?
Yeah, there isn't exactly a rate that's been defined. It's more if, for instance, the city had excess funds available after an audit, could be the council's discretion to authorize a certain amount to go in there, whatever that may be. But we haven't established a policy saying there's a specific dollar amount.
So it's not like a periodic set aside or anything?
Exactly.
Yeah, you're looking towards a sinking fund automatic, and no, we're not doing that right now.
Okay.
Because, and primarily the reason is even with the fluctuations, we've still been able to absorb those increases into a balanced annual budget.
A follow-up question. In the safety, you have classic, tier 2, and PEPRA. What's the breakdown of that 11? How many are classic? How many are tier 1? Or excuse me, tier 2, and how many are PEPRA?
Well, it's a function of when they were hired, right?
Correct. Yeah. So for right now,
speaking, the older employees are the classics.
Yeah. So for right now, we actually have only 4 in the tier 1 for the classics, and 7 are in the PEPRA.
And what?
PEPRA.
So
for
there's
safety.
nobody in tier 2?
Nobody in tier 2.
Tier 2 depends upon their membership status when they come into our organization.
And it was only a couple of years that we had that, so.
Okay, any other comments? Okay, well, thank you very much.
If I might, Mayor Catalano, There was an interesting tidbit that Laura discovered today, and it's part of the reason that we're not rushing as an entity to pay off our UAL, or unfunded actuarial liability, because actually in 1999, the city manager at the time recommended that the city contribute $1.4 million to pay off its UAL, because the thinking at that time is when you do that, then your UAL, I know, but that thinking at the time, the UAL disappears. And that's why my assessment of CalPERS and where they're at is that do not rush to pay off the UAL. It's like a mortgage, pay it off at the time. The difference between a mortgage and CalPERS is at the end of, let's say, a 30-year mortgage, you have a deed. With CalPERS, and I've used this analogy, they keep moving the goalposts, and so you never are ever to catch up. They will, while our side funds may be disappearing, they will look at other ways in which to
They'll
contribute.
do another actuarial and the bill goes up again.
Yeah, so we are paying fully each year what CalPERS requires us to do.
Your mortgage with the bank, the CalPERS is a loan shark.
That's right.
A good analogy.
Okay, very good. So let's move on to next item then, which is item 8B, which is the review and approval of the 2019 committee assignments. So I think since that's in my name, I think maybe I'll mention a few words first as to kind of the logic behind this. So what I tried to do, I mean, obviously now we have 2 new members on the council, which means we had a lot of assignments that needed to be reassigned and things changed around a little bit. But what I tried to do is really to balance the committees between all of us so that all of us have some assignments. And obviously some of these tasks are busier than others. Some of them meet regularly and require quite a bit more, and some of them are daytime assignments and so forth. And some of them are definitely much more ad hoc as needed committees that, you know, are not as busy, but then they do get busy at times. So I tried to keep that in mind. I tried to also align these a little bit based on different interests and expertise that I think is among the council members. And then I think the third factor for me was just trying to also provide some continuity and prior experience in some of these committees and assignments where I think that's relevant. So I'm not going to mention every single item here, and I've talked to each of you individually as to your preferences, and I've checked in on with all of you as to, before this went in on Friday, as to, you know, what was going to be here. So I think each of you knew before Friday what these assignments would be. But a couple of things, for example, in terms of the prior experience and continuity, there are a couple of things like the ABAC assignment, the Contra Costa Water District liaison, the downtown activities, where, you know, to a couple members that have had him previously have, you know, there's a level of experience I think needed, and or there's valuable input coming from prior experience in those. With respect to the Budget and Audit Committee, I think typically we like to, it's good to provide, if there's a new council member, have a new council member assigned to that, because there's a lot of valuable experience that can be gained in having to look at the budget and audit in detail. So in this case, since it's a 2-person committee, we have 2 new members, so it didn't seem quite right to have 2 new people there entirely. So that's the reasoning there, and I know that Councilmember Juan has obviously professional experience from the industry as well, so it made sense from that perspective. Then in terms of some of the other ones, you will see that there is one assignment that's not to a current council member. So if you look at the CCCTA assignment, that is not a mistake. So it is still listing Keith Hayden as the assignment. And the reasoning there is there's a certain level of continuity that I think is valuable in that assignment for the benefit of Clayton. And it didn't seem right to put an entirely new person into that task. And at the same time, the way in which the CCCTA works is that you do a number of rotations typically within that committee, and then, you know, you can, although it's not lockstep, but it can, you know, lead to a vice chair and chair position. I know that Mr. Hayden has done those 3 assignments at this point, so I think, although it's not a lockstep, I think there's a natural progression to him to be as the vice chair next year. And I did talk to Mr. Hayden, and he will be available to come to the council meetings in our report session to provide updates so that we will still stay in tune in that regard. Then in terms
Are
of...
we allowed to, like, is that like a thing where you can have?
So yeah, so we do have, so other cities do that, and we as a city have done that. For example, when Greg Manning stepped off the council after, 16, 18 years, he actually continued in that role for a number of years, because I think he had the experience, and I think it was valuable to the organization to have that happen as well.
You've been drafted.
So, yeah.
Well, I think
I
the
made
town of Mer-
comment regarding that when Mr. Manning was on that appointment, because I've got some clarifications I want to ask about the assignments. That was because no one else on the council was interested in doing it, so it was, by default, he was allowed to continue to represent the city at that level. Same thing is true for another city in Contra Costa, Moraga specifically. No one else from that city council wanted to sit on that board, and so therefore he was also allowed and continued to represent them. But even looking at that, I bring up a point of clarification. I'm not going to object to the appointments that you've made, but what I want to point out is that these are primarily city council member appointments and representatives. And it states further that it's the primary role of elected officials of the city council to be members of a variety of ad hoc and standing committees. Clarify for me.
That's correct, but it is also, like I mentioned, there are other cities that have, I think there's value in having, whether it's current or former council members or planning commissioners occasionally, because they do have the experience. But I think in this particular case, at least with respect to 2019, given the rotation that I think Mr. Hayden had done and being able to provide that continuity, and I know you and I spoke about this, that I was concerned about having an entirely new person in there and having them step into that role. So from that perspective, having that continuity made sense from that perspective.
Well, I did some investigation on that, and I talked to the administration over there, and the former occupant before Mr. Hayden had completed 2 of the committee assignments and was also moving up to the organization. In fact, was the board secretary in line to be the vice chair or vice president. And that sequence was interrupted by the summarial removal of that person from that committee. So explain to me why we're putting somebody in there that is not an elected city council member.
So I think I mentioned already. So I think it's a matter of continuity in that role, because I think that's valuable in that particular role, and I wanted to ensure that there's that continuity. And like I mentioned, we're not providing a citizen into that role. We're providing a former elected official into that role, and we've done it in the past. And like I said, Mr. Hayden is available to come update us so that we are still stay up to
Okay,
speed.
one last comment. When I talked to the administration over there, the former occupant would have picked up where that former occupant had left off. In other words, having completed 2 assignments, only needing 1 more to complete the 3, and then moving up to the leadership.
I understand. Okay, let me make, I didn't have many more comments, but let me make a couple other comments. So I think the one thing you'll notice is on the Do the Right Thing program. So I think in the prior year, so this was a program that was started by, I believe, then Council Member Hank Stratford, and I think Councilmember Shui was also very active in that. I think last year was only a 1-person committee, so I would like to make it a 2-person committee, and I've also already talked to Councilmember Wolf about that. I really would like to actually, at least for the 2019 year, to see about expanding that program a little bit, about including adults. So we'll do it maybe as a pilot program for 2019 and see where we can take it. So that's why it is a 2-person program this year, and I have some ideas, and I know Councilmember Wolf has some ideas as well. So for that reason. And then the other committee on the second page is an Unsung Heroes Program Committee, which is a program that I really don't know what it's entirely about, and I don't think we've quite kick-started yet, but I think it kind of aligns with the Do the Right Thing program, so for that reason, it's the same people here, and we'll see kind of how those blend. And then, a few other, like I said, there's a number of other assignments where just wanting to provide some continuity, but then introducing new members. There's things like the Mount Diablo School District liaison, which, there are two of us on this council currently that have our own kids right now in the system, so that made sense. And I know Councilmember Pierce has grandkids in the system, so as an alternative. So a few
You're
things.
more direct contact.
Yeah. So some of those
Pretty
made
sure my
sense.
son is in your granddaughter's class.
Oh, cool.
So, and I
And
think
my other son's in your son's
so we better make sure they don't form a quorum through us. So, okay, so that's all I had. So that's kind of my logic in those assignments. So I think if there's any comments, or otherwise, I think we'll just. And then I guess there's an opportunity for public comment. So if there's any member of the public who would like to address this, please approach. But seeing none, we'll close public comment. So then, if there's any discussion.
I have a question.
Go ahead.
Just a question. So I did read all the GAD documents, and it gave me a good idea of what the thing was all about. And I was able to find information on some of these others, but I understand that there's not like a concise description of the charter of each of these and what the intent is and what they do and what not. Is that something that, well, for me, it's worthwhile because I like to read. But is that something that is easily assembled, or just, we have all these committees and we serve on them and we do things, but it doesn't really say like you value continuity in the CCTA, which I assume is very good, but I don't know from my own personal experience why that is valuable, because I don't know what the person on the CCTA does. So, if there's information around like what some of these things do, that to me is useful. So I don't know if that's available.
Yeah, I don't think we have anything written about them, and I'm a little bit hesitant to ask staff to prepare yet another document. I think we want to run our city as well. So, I think, and they're varying degrees, because I think some of these are very active, and, it's very obvious, like the Library Foundation, for example, they have monthly meetings, and you attend the monthly meetings, and you act as a liaison between the council and the Library Foundation.
That one makes sense. That's pretty clear.
But some of the other ones, like the Garbage and Recycling Committee, for example, it doesn't have it's really when needed, and when it usually comes through our city manager when there needs to be some discussion that can happen in a committee format as opposed to having it as a whole in the
and as you mentioned that one, Mayor, actually that committee will become probably active this coming year, because Republic Services has a number of state mandated programs, the organics, waste, and others that they need to integrate into their services. So that committee will be meeting more frequently.
But things like the CERT committee, well, the CERT used to be really active here in Clayton, but it's pretty much defunct now because that group of people has pretty much moved on, and nobody has replaced them. So I don't know if it's going anywhere or not. Maybe Jim can get it kick-started. That would be nice to train a whole new crop of people. But there are some of these others. The Downtown Activities Committee, I don't know, Jim and I both work on the concerts and a lot of the other events, but I don't know that we actually have any formal meetings. We didn't last year. We just did what we do. But if something comes up, then it would come to us to talk about some of these other things. The Endeavor Hall Marketing Committee, that's one where several of us in the past have been on it, and nobody's been able to think of a better way to market it or to make it more profitable. So if we have some brain trust of ideas here, that would be great. But, it's if somebody gets a brilliant idea, they're the ones that are going to talk about it and make a recommendation to us. It's not like it's a lot of work. I think most of the others pretty much speak for themselves.
I guess maybe I started with GAD, so that one has the most.
Well, that one's the one that is the most prescribed because it's to run that hazard abatement district. But most of the time, it's not doing anything, and it doesn't have any money to do anything, even if we needed it to. So.
If I might, council members, the question is well taken, however, because I know each year when we look at 3 CTA, we as staff often say, okay, how often do they meet? Or if we're looking to appoint someone to their advisory committee, we want to inform a citizen what the meeting requirements might be. So, well, give us a chance. We can create some, several, just a paragraph or whatever, or less, or less, or okay, one word, and just to kind of give it a basis. We don't want to be limiting to what they are doing by doing that. We don't want to box them in, because as Vice Mayor Pierce indicated, if there's something in the downtown that, let's say, CBCA has an issue with the city or whatnot, and that rises more to a policy call, in terms of how you might handle that, then we would ask that committee to convene.
Yeah, it's descriptive rather than prescriptive. So,
so we can come up with something.
Okay. Okay. So if there's not any further discussion, then I'd look for a motion.
I would move
So there was
approval.
no other interest in the CCTA position, is that correct?
You and I had a discussion about
I
this.
don't want to get into personality. Was there any other interest from a current elected city council member?
I think you know the answer to that one.
I want you to publicly answer it.
I did not express an interest.
Okay, thank you.
Neither did I.
Nor did I, and I have had conversations with several of the members of the County Connection Board, and they are all looking forward to having Keith come back.
So you're not going to answer the question?
I think it just got answered.
Okay, thank you.
Okay. Any further discussion?
I would move approval of the assignment list.
Is there a second?
Second.
So it's been moved and seconded. All those in favor, please say aye.
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 And any opposed? So none, so it passes unanimously. So then let's finish up here. So we have item number 9, which is the opportunity for any council member to provide any requests or directives for future meetings. Any?
So I have a question. We had talked, I think, or Jim, you had mentioned that you wanted the parolee housing issue to come back, and I think that was scheduled at some point. I just wanted to confirm that that's actually scheduled. Is that something that we could do?
Well, based upon what I've seen in the schedule, the earliest we're going to do it is mid-January.
Well, January 15th is our next meeting, right?
Right.
So, wait, hold on. Is there a schedule?
Pardon me?
You said what you've seen on the schedule. Are you talking about the schedule of council meetings?
Yeah.
Okay.
That's the next time that it could come up.
Well, is it coming up January 15th?
Unless there's something that I don't know.
Do you expect it to come up January 15th?
Pardon me?
Do you expect it to come on the agenda at January 15th?
Yeah.
Is that the current going plan?
I guess. He's the schedule maker, not me.
Yeah, so I just want to confirm, whoever wants to confirm that. And the reason I ask is because I think, typically we give 3 days, or a minimum of 3 days, and I think we usually do it Friday, so that's more than 3 days.
If I might just assist, I think in my staff report on the cancellation of your January 2nd meeting, I outlined what items I'm looking for to come for January 15th. And Councilmember, I sent you an email last week asking to confirm that January 15th was okay with you. And I think what Councilmember Juan is saying is that still a good date?
It's a good date.
Well, and the reason, maybe we're not clear. The reason is under future agenda items or council items, the person who asked for it to come back takes the lead on that item, not staff.
Correct, and I did not ask staff to do any work on it.
I didn't say
and
you
that
did.
I am doing the background right now, dealing with the people in the county. When I'm ready, I'll come back and bring it back to for a proposed agenda.
Well, now that's different, so
So are you saying not on the 15th?
I thought that was clear when I gave the letter to the former mayor. That I didn't say bring it back on January 15th. I said,
sometime after the new year, is I think what you said.
I needed to do some background, and I have been doing that due diligence in the background with the people from the county, and I suggested to them that I would be back to them and meet with them to further discuss this. Probably right after the first year, yes, but I don't think we'd be ready to discuss it or bring it to a city council meeting at that point.
okay, so It's not, what I'm hearing, the conclusion, it's not on for January 15th.
Absolutely correct.
And that you will notify, according to our policy, the mayor and
Absolutely
myself
correct.
what meeting date you would like to bring it forward.
Absolutely
Okay,
correct.
very good, very fine.
So that's good clarification there, because I was under the impression that it was going to be January 15th, so.
Yeah.
And that's fine.
And to be clear, so it would not have been the actual item coming back from staff with a staff report indicating change or whatever. It would
The
be
discussion
really, it would be the
on whether or
discussion
not-
by the person who makes the request to the other council members as to here's why I would like to bring this and have it actually agendized. And then if there's consensus, then it would be brought back, correct?
Correct.
Okay.
So then it would be put on the agenda down the road?
Only if the council directs
yes,
that it
direct.
so is preposition.
Well, it would appear as an action item with the initiator leading the discussion, and if the majority of the council decides that there's something that they want to tweak on that item, then they would instruct staff and we would bring it back at a subsequent meeting.
Okay.
So if you pull something out, you're the lead person, the staff doesn't do any work, and then it's up to you to bring it to the attention of the council, then we have a discussion, and then it gets on the
Correct.
agenda.
It's the council as a whole that
Okay.
drives the organization.
Just getting the procedures straight.
So are there any
So
actual requests?
Yeah, I would like to have, we had talked about city objectives, I mentioned it earlier in the year, or in the meeting. I think I've been looking at some of our previous objectives over the past several years. I would like a semi-annual report from staff regarding the status of the goals that we've established as directed by the council, including what we've done, what is planned to be done, and an outline of how each of those goals is expected to be achieved and when. I think that if we create this report out, it outlines a process for evaluating ongoing items that direction has been given to staff, as well as a way to address them if they're still good, if we want to eliminate them. Maybe we create a mechanism or a rubric that says if there's been no activity for greater than some period of time, like several years or whatnot, that we eliminate them from staff's list of things that they have on their plate. I think that helps us ensure monitoring of our existing goals. In what I've seen, I think we have something like greater than 25 that are outstanding, and some are fairly recent, like this 1505 thing that we talked about earlier, and that's this year. But there are others that are 5 and 10 or greater than 10 years old that are outstanding, and I think doing this would give us an opportunity to address whether the actions directed by a previous council are still good and that we want to continue them.
So let me interrupt you at this point in time. The process would be that Councilmember Wanda identified a subject matter to be brought forth at a future agenda meeting. It's not
a discussion.
It's not a discussion at this
No.
point. Otherwise, our city attorney.
I
will be in.
understand, and I agree with that concept, but I'm wondering if the discussion would be better held in our goal-setting session where we could actually put it in the context and discuss how we got to some of those goals and why they're there for continuing times and that sort of thing.
Yep.
Have a discussion in that context. And then we can bring them out and announce them to the public and make sure it's transparent and all that sort of thing. But I think some discussion about how we got there and why they're still on there might be valuable.
Yeah, I was aware that this matter might come up, but Vice Mayor Pierce, you're kind of thinking along the lines of what the discussion now I would have subsequent to this meeting with Mayor Catalano is
Right.
looking at what's a good meeting to facilitate that. And I'm thinking that on your January 15th meeting, I'll be asking you to set a date that's mutually agreeable for everyone to have a public meeting to discuss your goals and objectives. And then we could work through some of these things as well at that time. But that we'll have that discussion.
And I think that's fine. I think that's independent of what I'm asking, though. That's not what I'm asking.
But if you're asking for reporting, I mean, you do get a weekly report that includes
I want a
status.
public report.
Okay, but I think that's better done after we have that discussion so we
Sure.
can make a comprehensive
Sure,
report.
and that's fine. I mean, it's not like this is going to come up right away, but I do think that just the nature of our activity, we set goals, it's good. We have weekly reports on goals, that's good. But I don't think that there's a set time for the public to evaluate our achievement of these goals and whatnot. So what I'm asking for is that there is a set cadence for a report out that hits on those things like existing status, what is going to be done, what is left to be done, what's the time frames, things like that, so that we self-evaluate on a more frequent basis. That's the request.
Yeah, and like I said, I've only been at the goal-setting sessions twice, and you don't have the benefit of that, doing that, but a lot of that happens in that session. But I think, I mean, if there's consensus, I mean, we'll have some of that discussion anyway at the goal-setting session. So
Yes, I'm sure that will happen, but that's independent of what I'm asking. I think that will happen no matter what, regardless, and that's good.
Yeah, but I guess if you want the reporting to be different than what you're getting on a weekly basis, then it sounds like that would still be something to be discussed at the goal-setting session.
How we do that. That's fine. We can do that.
Okay, and I could put it more in writing if it helps clarify to introduce the topic at a later time.
I think we got it. Yeah. And we could do it on a regular basis, too. That's not a problem.
Okay, any other items or requests?
But actually, well,
Go ahead.
okay, so just so I understand process correctly. So I am asking to give direction to staff to do something specific, and I think that needs to come, holy crap. I think that needs to come from the council as a whole, correct?
And I think
So for us, but we're not discussing the merits of that right now because rules. But so I want that to come up as a future agenda item so that we can discuss the merits. And so I don't know if we at that point we describe the contours of what that is, and then we could discuss whether or not that's a good idea or not. And that's what I want to have on the agenda.
Right.
My suggestion was that be part of the agenda for the goal-setting session. And talk about how do we then present our goal-setting and accomplishments to the public. As part of
What I'm hearing, Vice Mayor, is that the council member is saying, fine, that's a good dialogue at the goal setting, but he also wants it on a future public agenda.
Yes.
But you could always request it after that, too, once you kind of
Sure.
have the...
But I'm
the
also
value.
requesting it now, though, just to be clear.
Okay, but do you want to hold it before the goal-setting session?
Well, the goal setting is going to be at our next meeting.
No, we're going to set the date for the goal-setting.
Set the date
January
for the-
15th. Yeah. So we'll set a date at that point, then we'll have, whenever that goal-setting session is, you can always repeat the request. And, you know,
I don't know if it's a big deal either way.
no, I mean, from my perspective, it seems it's a little premature, perhaps, that I think it might be beneficial to go through the goal-setting session first, and then, so that we can actually have a discussion in that context.
Otherwise, will it come up on the January 15th meeting?
The January 15th meeting has several items already. So, but that's what the policy is. The mayor and I discuss what meeting, would best sit for that kind of grouping to take place. I don't know. I don't have anything in front of me as to what I'm tracking for January 15th. So it may or may not. Well, I think, Councilmember, what your colleagues are saying is there's maybe benefit to waiting until the goal-setting session occurs, and then you can get a feel for what takes place at that, and that could better assist you in facilitating a discussion of what you're looking for.
Okay. The goal setting typically takes place, the first or second meeting of the year?
Well, what we'll do on January 15th is, I think, Mr. Napper will provide us a calendar, and we'll actually set a time and date for that.
That we can all do that.
Yeah, so that it will work for everybody. So,
It's
probably.
usually not, sometimes it's been incorporated before a standard meeting, sometimes it's held separately. And that's what the council will decide. But it's public, either way.
Okay.
So on January 15th, we'll find a date that works for everybody, and we'll set that date, and then we'll have it, and we'll have the discussion itself, and then you can certainly,
Okay.
I think it will evolve from there. Okay, good.
And I also, I think we, as a future item, exploring an alternative to Roundup type products is a worthwhile discussion for a future meeting.
Or maybe just get a report back from staff on what their plans are. I don't know.
Either one of those.
Yeah, I don't know that they're making a plan
Yeah,
already.
I think a discussion will probably encompass that as well. At least an information gathering session. And then, so you got point on the parolee housing, or like, can we both request it, or no?
I still have some background work to complete before I'm ready to move forward.
So if we both request it, but his delays, does that mean like, is there like, do you do it twice?
I hope not.
Okay, so I'll that's going to happen shortly though?
Yes.
Okay. I'll defer to that.
We're good?
Okay.
Okay, we're good? Good. Okay, so let's, then we'll move forward. Item 10 is closed session. We do not have any, so we are adjourned then until our next meeting on January 15, 2019. However, we do have another agenda, so I would like to call to an order the Clayton Successor Agency meeting for December 18, 2018. Let the record reflect that all board members are present. Our first item is consent calendar. Do you have a motion to approve?
So move.
Have a second? So it's been moved and seconded. All those in favor, please say aye. Aye. Any opposed? Seeing none, it is approved unanimously. Then we move on to public comment, which is the portion of the meeting when any member of the public can address the Clayton Successor Agency on any item that's not on the agenda. I don't have any speaker cards, and I'm not seeing, would you please go ahead?
I'm going to make one comment. This is Ann Stanaway, 1553 Haviland Place. I am officially nauseous, really and truly. I'm sick, and so I need to exit, get out of here. So I'm just saying, adios.
Okay. Have a good night. Thank you. And seeing no one else come to the public podium, we'll close public comment. Public hearings, we have none. Action items, we have none. Are there any requests or directives for future meetings for the Clayton Successor Agency that any board member would have? Seeing none, we will adjourn until our next meeting when as needed. And that is it.
And we got to take a picture now.